Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
The wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
You will bring the jury.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on
Remember in the beginning when we started 110 years ago?
All right. I made a mess of that one this morning, this afternoon. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Let's see. I don't want to have a gripe session, but a couple people have been a little bit rude today, directly to me. Thanks, I appreciate it. It's all right. I know you don't understand. I have a lot of things on this channel that run in the background, software that needs to run, things that need to link up and connect in a certain process in order for them to work, like the seats and the commands, things like that. When that software requires to be patched midday, like it does sometimes, or first thing in the morning when it does sometimes, I can't just start, or else things won't work, and then I get a lot of complaints. So yes, sometimes we are a few minutes late. That's why. It's running the things, getting everything in order for you. It's getting the court queued up and the correct feeds and the audio levels adjusted as best we can. And if you don't like it, there are also other places you can watch. So I would just go ahead and put that out there. I'm not in the mood for fighting about that anymore. But I do understand that you probably had no clue as to what happens on this end. I tried to be a little vague about it this morning and getting some more messages. So thank you all for that. It's all right. We're all good. We're going to go back to court here in just a minute. Yeah, it's all good. It's all good. Welcome, Kim R. First in chat this afternoon. Kim, congratulations. Everything IP related worldwide is your fault. Not just your fault, it's your responsibility. Thank you. Do I have the guts to patch the same day? If I had my way, I would never patch, JMR. But some of the software, literally, when launching, which you have to launch every single time after the feed starts, so you have to wait for YouTube to recognize the stream and code it properly down and get this feed going so that we can see it there, and then you have to launch the other thing. When it launches, it automatically patches. It doesn't give you any other option. Otherwise, it just doesn't work. So it's one of those things that you just can't deal with any other way. So yeah, I can try to be on time, and in this case, Lumia Stream can say, "Oh no, we have a patch for you, and it's going to take as long as we decide it takes." So that's good. All right, welcome all. It's good to have you here. We're in the middle of day one of a crazy trial out of Virginia. And this is the trial of Ebony Parker, who was the vice principal at a little school in Newport News, a little elementary school in Newport News. Not little, had about 500 students there. And on this particular day, particularly, we're talking about January 6th of 2023, a 6-year-old student, a first grader, came to school with a gun in their bag. The first grader was acting differently that day. Not differently from all previous days, because he had some behavior issues previously as well. Enough so that he was on a special plan that only had him in their regular classroom for a couple hours compared to the rest of the students who were there for the most of the day. He had special, tutoring, one-on-one type things with reading and some other stuff. Some teachers noticed and some students noticed. And throughout the course of the morning, as things progressed, the teachers and by extension, and through the teachers, the vice principal were notified of the problems they were recognizing this kid and the potential for him to have a weapon at the school, even that some people had said he had a gun. And the failure to act by that vice principal is what led to the 8 charges she is now facing of negligence. 1 charge for each of the bullets that were in the gun. The student did, in fact, take the gun out of the backpack in class, shot his teacher, Mrs. Werner. It went through her hand and into her chest. She survived. But the gun, which I believe was a semi-automatic from the way it's described, jammed, and the remaining 7 bullets were not able to be fired, which could have saved other people, or probably saved other people. So 6 years old is the shooter. Shooter's obviously not charged. The mom has been charged for her role in the child being able to get the gun from home. Obviously, she didn't give it to him, so directly, but she's been charged. I think she's doing 4 years, or might have served time already. I'm not sure what that status is. The teacher, Mrs. Werner, has already civilly sued the school and won. Asked for $40 million. He received $10 million in that case. And now we have the assistant principal on trial criminally for failure to act in this case. With those 8 charges, she could be facing a maximum of 40 years in prison. So that's what brings us to where we are right now. Let me just bummer. All right, let's see. Good. I just need to make sure I didn't show something I wasn't supposed to as far as streaming keys went, and we're good. Let's go to court. Are you guys ready? We're picking up with testimony. We've had a testimony from a couple witnesses so far this morning, including Mr. Zwerner, or Miss Zwerner, the teacher that was shot, the reading teacher who interfaced with Mrs. Werner and directly with this student at several points during the day. She was also the one who, as soon as the gunshot went off, rushed into the classroom and restrained the student until police arrived. So a bit of a hero there. Both of them have been thrown under the bus by the defense, who was saying they should have done more to stop the shooting, not the vice principal. So let's jump back to court and see where this is going to take us. Let's see. All right, let's get a little background blue going. Is that all right? Little blue. That looks good.
The case of Cumberland versus Parker after our lunch recess. Is there anything we need to take up before bringing jurors back out?
Nothing from the Commonwealth.
I don't think so. All right, Sheriff, would you please bring the jurors back out?
Interesting thing about this court is at several points we have had the judge making questionable rulings on foundational issues like hearsay and relevance, and the prosecutor has had to gently instruct the judge as to what the law is and what the law isn't. At one point, the judge even got out the books to consult to see what the definition of hearsay was. So we've had an interesting morning. Blue matches my shirt. I'm blending right in.
Please stand for the juror.
We're after lunch yesterday, yes.
I have 14 jurors in the box. You may be seated.
I think the bailiff is bragging. I've got 14 jurors in the box.
Okay, now we're ready to resume the case. You have all 14 jurors present. And the Commonwealth will call another witness.
Yes, Your Honor. The Commonwealth will call Landa Rusk.
Pretty wood. There's a jury waiting room and a witness waiting room. It's like a green room, I guess. I'm sure there are mirrors and beauty lights around it, so everyone can look at their best for court. Phoenix Rising, good to have you here. Welcome. But is it heavenly wood? This is a great question.
favor, if you could stand in front of Madam Clerk and be sworn.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Watch your step, stepping up. Step. And you swear.
Thank you, ma'am. If you need to adjust the microphone, you can. Please answer questions the attorneys may have.
Good afternoon. Would you please tell us your name?
I'm sorry.
Could you please tell us your name?
Landa Sample Rusk.
Thank you, Ms. Sample Rusk. We have a court reporter taking everything down today. Would you mind spelling your last name for us?
SAMPLE-8RUSK.
Thank you. I want to remind you that during your testimony today, we're not saying the names of any children, only using initials if we need to refer to them, including your own grandchildren or children. We'll only use initials or refer to them as your grandchildren, if anything, okay? Let me ask you, Ms. Sample Rusk, on January 6th of 2023, did you go to Rich Neck Elementary?
Yes, I did.
And what was the reason that you went there?
I went to Rich Neck to pick up one of my grandsons.
Okay.
Who was a first grader there.
And you have how many grandsons that attended Rich Neck at the time? 2. Okay. And when you got to Rich Neck, did you go into the office area?
Yes, I did.
And if you remember, who was in there when you first arrived?
When I entered the office, it was the 2 receptionist secretaries. And there was a student sitting to the right when I got in the office.
Okay. Do you know the names of either of the secretaries?
I believe one was a substitute there because the other was on vacation. I'm not sure, but the other one was there all the time, and she goes by Ms. O.
Miss O.
No, yes,
Okay.
I think it's I don't know that case.
That's okay. Thank you.
We always call her Ms. O because that's what my boys call her.
Okay. Now, while you were there in the office, did something happen that took you by surprise?
Yes.
Can you just tell us what it was, what you saw happen?
I was in the office for a little lengthy time because I was speaking to the receptionist. We were talking about cruises and different things. I'm sorry.
You can take a minute, take a deep breath. It's all right.
Iris, welcome. Hey, I am Super T, an apology. I saw your super chat and missed it this morning. I'm so sorry. Your membership milestone. I read it.
Employee of the school. I don't know her name. I believe it's Miss Harris. I'm not sure. She ran into the office and she said she yelled something about a gun or shooting or something like that. So I was still on the side of the counter where I should be as a visitor in the school. The receptionists were still at their desk. But when the teacher ran in, she ran in and went straight to Dr. Parker's office and closed the door.
Okay, so the teacher went into Dr. Parker's office?
Yes, the entrance from the office.
Okay.
Because there's an entrance to Dr. Parker's office from the main office.
Understood.
So, and to both the principal and vice principal's offices from the main office.
So after that happens, what's the next thing you see happen right there where you are in the office?
As she ran in and shut the door, we didn't have any information. And then, or I didn't know. I can't recall exactly. I can't recall verbatim, but we found out it was a first grade class.
So you don't need to tell us what you heard, but really, or what you thought was going on, but just describe it visually. Like, what's the next thing that happens in the office where you are?
Miss O jumped up, got on the phone, and she called whatever code they call out to the teachers over the intercom. to let them know that there was something going on.
Okay.
I was a little hysterical because when I found out it was a first grade class, I was ready to go down the hall to find out what was going on because that's my kids down there. So
now, at some point, does another teacher come into the office?
after that, we called the police, everything. Then, just as I took I was wearing a crossbody purse. Just as I took that off and set that and my keys on the counter, I was going to go down the hall. Before I could get out the door, Miss Werner comes into the office and she's holding herself like this. And I see blood on her hand. And so, by that time, when Miss Werner came into the office, I had gone behind the main desk that we're supposed to be on. I was back there where the employees would have been. I had stood behind there because I didn't know what was going on. And I took the little boy that was in the office, took him back. I said, look, you need to hide. I said, hide. I said, my name is Miss Landa. I got you. I said, you hide. The kid hit so good I couldn't even find him after I really looked and looked for him. But he was back shoved up under the one of the big copier machines. Okay.
So let me ask you a question. So while you were telling him to hide, and where are you when you're telling him to hide?
I went to him. I walked from behind the counter, walked to him, took his hand, let him know. I said, my name is Mr. Wanda. I have a grandson here. I said, you're going to be okay, but I need you to hide until we find out what's going on. And so I made sure he was secure. Yes. And then when I didn't see him, and I knew he didn't walk out the office, I knew he was secure.
So at that time, after he got secure, where was Miss Werner, if you know?
So I secured him before Miss Werner came into the office.
Thank you.
He did not see any of that.
Thank you.
I got him out of the way because I didn't know what was going on. He did not see any of that.
I understand. So let's pick it up from that moment where Miss Werner, he's hidden and Miss Werner comes into the office. What do you see?
Miss Werner comes into the office and, before she came into the office, we locked the office door after the teacher came in and went into Dr. Parker's office. We locked the door. We didn't know what was going on because I locked the door. I ran and locked the door. Then, so when I saw Miss Werner, she came to the door, and I had to unlock the door for her. She came in and she was holding herself, and she said, "I've been shot." She was very pale, and then as she walked into the front office, to the right, immediately, like side by side with the counter, there was a principal's door. Ms. Werner fell there. Okay. When she fell, I lost it. But I was trying to keep my composure because she fell out. When she went down the wall, there was blood on the wall. So I went to her. Well, the secretaries were doing what they were supposed to do, whatever protocol is. I don't know. I'm not an employee. I cannot speak on that. They were doing whatever they were supposed to do to make everybody aware, get law enforcement there, whatever.
Your Honor, I'm going to object to this testimony, this line of questioning. We are here again regarding Dr. Parker's actions and inactions on that day. This is beyond the time when Ms. Werner had already been shot by JT. I don't see the relevance here.
Dr. Parker's inaction caused exactly this that's being described. So this is exactly the same as the prior ruling regarding Ms. Kovac's situation in the classroom. This is the shooting's aftermath, and it is the result of Dr. Parker's willful inaction.
Again, how is that
relevant. She's charged with child endangerment, and we're talking about the medical response and the response to the people that see that in the office. Is there still child endangerment happening right now? Is that what you're alleging?
Absolutely. There is a result of the child endangerment. There is a prong of the statute that requires proof that the child was in danger and possibly deadly danger. And we have a grandmother who is shuttling a child to safety in that office as the event is unfolding. This event is entirely precipitated by the child neglect. But for it, none of this would happen.
So, let's streamline it, because it's going into narrative where she's just giving a narrative and not answering the question. Can you ask another question, please?
Yes, and if I may just sort of inform the witness, I'm going to need to ask you questions, so just pause with me for a moment and we'll walk through it step by step, okay?
Okay.
At the moment that you have described where Miss Werner fell down to the floor, can you tell me, at that moment, you've said you were with her, do you know where the office receptionists were?
Yes, she was on the phone.
Okay.
Nicole was on the phone.
All right. And do you know where Dr. Parker is?
I didn't see Dr. Parker.
Okay. And do you know where the principal, Miss Foster, is?
I didn't see Miss Foster.
Okay. And so while you're there with Miss Werner, and at the time that you let Miss Werner into the office, did you see Dr. Parker or Principal Foster?
No.
Okay. And so after you have seen Miss Werner slide down to the floor, what's the next person that comes to the office? Who is the next person that comes to the office is not a leading question.
I think technically it is, because it presumes that somebody else does come.
Well,
so can you rephrase it to who was the next person that comes to the office, if any?
Did anyone come to the office after that?
I don't remember.
Okay.
I honestly don't remember.
Did you ever see a police officer?
Okay, now, I can speak on who came, but as far as the next person,
okay.
I want to be very specific with my answers to make sure I'm answering this correctly.
Absolutely. Let me ask you a specific question. Did police officers come and attend to Miss Werner?
Yes, there was one officer I remember, I believe he was a sheriff's deputy.
You don't have to tell us any more about it. That's good enough. And at some point, do you find the child who had gone into hiding?
Yes.
Okay. And at some point later that day, are you reunited with your grandchildren?
Yes, I was.
All right, thank you. I don't have any further questions for you. Please answer any questions from defense counsel.
Okay.
Oh, man.
One moment, please.
Here it comes. Take your time, take your time. Step right up to that lectern with the microphone and then speak clearly and try not to make noise with the microphone, please, sir.
Good afternoon, Ms. Sample Rusk.
Hi, good afternoon.
All right. You mentioned that when you were in the office, you heard a teacher, or you saw a teacher go into Dr. Parker's office and close the door, correct? And so you don't have any personal knowledge of anything Dr. Parker said or did at that, before that point, or after that point, right?
Well, I did see Dr. Parker after the police and everyone got there.
Understood, yes.
She saw her come to the office, but and the principal as well, but in reference to Dr. Parker, no, I didn't see anything. I didn't see her at all until the end.
Okay, so you don't know what was going on in the office, right?
I don't know. All I know is she closed that door and stood there and watched us.
Hold on. You said
teacher.
The teacher closed the door.
Closed the door. I did not see Dr. Parker at all.
Okay, so you don't know what Dr. Parker was doing in her office? You don't know what calls she was making or anything like that, correct?
Correct. That is correct.
The teacher came and guarded the door to the vice principal's office?
You don't know what instructions she was giving? Anything like that, right?
No, I don't.
Okay. Ms. Sample Rusk, is it true that you filed a lawsuit in this courthouse arising from these events on January 6, 2023?
Objection, relevance.
Oh, it definitely.
Okay, well, yeah, you can respond.
Okay. It's definitely relevant and it goes toward potential bias, Your Honor.
Okay, how's it not relevant?
Well, whether she filed a lawsuit in the suit or not, I don't understand how that's relevant to whether Dr. Parker committed child neglect. Connection.
I think the law allows parties to cross-examine on a witness's interest in the case. If she's filed a lawsuit, she may or may not have an interest in the case. That's proper grounds for cross-examination. So you may proceed. Do you need him to repeat the question?
Yes.
Please repeat the question.
Okay. Ms. Sample Rusk, you filed a lawsuit in this courthouse regarding the events of that day, correct?
A lawsuit has not been filed yet.
Okay.
Has not been filed
have
yet.
you made any demands of Miss Dr. Parker or her attorneys?
I'm not sure I understand that. Have I made any demands of her? I'm not sure. Can you? I don't understand. I want to make sure I answer
Understand.
correctly.
Right. Regarding a potential settlement, or have you made any demands whatsoever of Dr. Parker or her attorneys related to that event, to that day?
I have not, no. And as far as I know, there has not been a lawsuit that has been filed yet.
Yet. Okay. Do you know whether one has been drafted?
No, I do not know that.
Have you retained an attorney?
Yes, I have.
Okay. And is it your understanding that a lawsuit, whether it's been filed or not, would be against Dr. Parker as a defendant?
That is correct.
Okay.
The teacher was Miss Zwerner. It's like Werner, but starts with a Z.
And before you came into that office that afternoon, you have no idea of anything that occurred before that point, correct?
That's correct.
No further questions.
Can you agree with the rest?
No, Your Honor.
Thank you. All right, and the status for this witness?
Do you want her subject to recall? I would ask that we release her.
Okay, any objection?
No objection.
Okay, so and that means you are released. You are excused being a witness. So you may stay in the courtroom if you wish, or you may leave. Thank you very much. And watch yourself as you step down.
The Commonwealth will next call Kelly Wells. Kelly Wells.
Kelly Wells is the next witness. Hopefully she speaks loudly and into the microphone. The audio is really rough here today. They have what's called condenser microphones that are picking up all the sound that bounces around between these hardwood paneled walls and don't pick up the sound we want to hear.
In front of Madam Clerk to be sworn.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
And okay, please step into the witness stand. There's a step. So watch your step. You can adjust the chair and microphone. Okay, please proceed.
Good afternoon. Would you please tell us your name and how you're employed?
Good afternoon. My name is Kelly Wells, Kellylywells, and I am a forensic specialist with the Forensic Services Unit of the Newport News Police Department.
And as a forensic services technician with Newport News Police Department, What is your regular job? What do you do?
I respond to major crime scenes, to include homicides, aggravated assaults, any death investigation that is unnatural or unexplained, and just anything else that is deemed needing forensics.
And when you get onto a scene, what do you typically do with physical evidence that you find?
Typically, I initially take photographs, and then I identify the evidence that I see, and as well as search for additional evidence. And I collect that evidence and will either usually process it for fingerprints or swab it for DNA, and potentially send it to the lab at a later time. But it then is secured in our forensic services unit.
How long have you been doing forensics work?
This is my 21st year.
I want to direct your attention to January 6th of 2023. On that day, were you called on to go to Rich Neck Elementary School?
Yes, I was.
Is that here in Newport News?
Yes, it is.
When you arrived at the school, were you directed to a particular classroom?
I was met by my sergeant at the time, which was Sergeant Ramdahall, and he accompanied me to classroom 11.
All right. And in that classroom, did you look for any evidence?
I did.
In that classroom, did you see a firearm?
I did.
Could you just describe where it was and how it was positioned?
Sure. When I entered the classroom, it's rectangular shaped. To the right is the front of the classroom, so the desks were facing towards that direction. And then to the left, there was a table that was behind in the back corner, behind the student's desk. On the floor by that table, there was a Taurus 9mm firearm on the floor. And then just in front of that, there was a student's desk that had a black and white backpack on the floor. And there was a Win 9mm cartridge case on the floor as well.
Okay. So let's talk about what a cartridge case is, just in case some people may not be familiar with that term.
Sure.
What is a cartridge case?
Lots of times people just generically will refer to ammunition as bullets. But typically, bullets, what you're thinking of is a cartridge. And the cartridge, which is ammunition, is comprised of a cartridge case, powder primer, and then a bullet, which is the projectile, all in one creates the cartridge. When the cartridge is loaded into a firearm and the trigger is pulled, the firing pin of the firearm strikes the head stamp of the cartridge, causing an explosion with the primer, causing the bullet to propel down the barrel of the firearm and out. And then the cartridge case that remains is then ejected from the firearm. It usually ejects back into the right.
So you have indicated you found one cartridge case. Where was that?
That was at the desk just in front of the table that was on the back left side. It was on the floor.
All right. And then with respect to the firearm, what did you observe about the firearm itself?
The firearm itself, I noticed initially that the slide was back partially. And the slide is the top piece of the firearm. And then I was able to get on the floor and look, and I could see at the opening that there was a cartridge jammed in the top of the firearm.
Okay. And would that have been an unspent cartridge, could you tell?
Correct. It had not been fired.
Okay. And did you determine whether there were any other unfired rounds or cartridges in the firearm?
Yes. Once the firearm was cleared for safety by my sergeant in my presence, we observed, or I observed 6 Win 9mm Luger cartridges and the 7th from the chamber.
All right. Thank you, Ms. Wells. Please answer any questions from the defense counsel.
Sure.
Where do you think I got my skills? I was Vanna's stand-in replacement, should she ever miss a day. I can turn letters like the best of them.
No, we don't have any questions.
Okay, no questions. All right, and the status for this witness?
She'll remain on call, Your Honor.
Any objection? Okay, so Ms. Wells, you're free to leave the building, but you're still sequestered, so you cannot discuss your testimony until you've received information that the case is over.
All right.
Okay, and they have your contact information, they can call you back.
Yes, Your Honor.
Thank you.
Thank you.
All right, next witness.
Commonwealth calls Jennifer West.
Jennifer West. Well, she's coming up. Just a little background on the judge. This judge is just completing her first year on the bench as a judge in this court. Before this, she was a judge in juvenile and family court for a number of years, like 6 years or so. Before that, before she was a judge, she was a chief public defender for 3 years, 2 or 3 years, supervising attorney for 9 years, and a public defender for 2 years before that. She graduated from JD Georgetown University Law Center with a Juris Doctorate. That's the JD part. And she has a bachelor's from University of Mary Washington.
The testimony you're about to give is the truth, full truth, and nothing but the truth.
And Ms. West, please enter the witness stand right here. And as you go around the corner, there's a step. Watch the step.
She is a native
Please answer questions the attorneys may
of
have.
this community and has ties to it.
Good afternoon.
Hi.
Could you please tell us your name?
Jennifer West.
And Ms. West, how are you employed?
I'm a teacher.
Now, I want to take you back to January of 2023. Were you a teacher then as well?
Yes.
What school did you teach at?
Rich Neck Elementary.
How long have you been a teacher?
23 years.
And what grade did you teach at Rich Neck back in January 2023?
First grade.
Could you help us understand where, if you know, do you know where Miss Werner's classroom was?
Across the hall from mine.
Okay. Taking you back to that January 6th date in 2023, on that day, based on, for whatever reason, did you end up observing a student named JT while he was at recess?
Yes.
And where was your class at that time?
Also at recess.
Okay. And while you were observing JT, could you describe, just as if it was a movie that we were watching, just the actions that you observed?
He and another
And I'm sorry for interrupting you, but I need to at this point because I forgot to remind you, we're not using any names of students. You can say a student or you can use initials, but please don't say the names of any students.
He and another student kept going behind the rock wall, and there's a large tree on the playground. They'd go back there and come back out, and I just was watching their interactions.
Do you know the initials of the other student?
RR.
And do you know the initials of the first? Okay. So describe for us what exactly JT and RR were doing in as much detail as you can remember.
It's hard to remember specific details, but I did write down notes the day of, and I reviewed those before coming.
When you reviewed your notes, did that help you refresh your recollection about what happened?
Yes.
Okay, well, then what happened?
They were staying together, very close together. They kept going behind the rock wall, going behind the tree, kind of being secretive, trying to avoid other people.
Okay.
I'm going to object a second.
I'll agree that the trying to avoid other people part should be stricken.
Okay. So sustained, strike that part, trying to avoid other people. But you can consider going behind the rock wall. Next question.
Ms. West, when recess ended, did you have a conversation with RR?
After we got back in the building.
Okay. And before I ask you to tell us what RR said, can you just describe his physical demeanor, how he appeared to you?
So I asked him to come speak with me to ask him about what we had observed at recess.
And before you tell us what he said, I just want to know his demeanor, how he appeared.
He was visibly shaken, nervous, I asked him what they had been doing, and he said...
Okay, hold on.
Wait,
Before you tell us what he said, I'll ask judge and counsel if we need to voir dire this witness.
Or are we going to get a hearsay objection?
Just hold on just a moment, okay?
Visibly shaken. Not sure if that qualifies for excited utterance. Is that enough? It's after recess.
Your Honor,
She calls him up.
I think based on previous rulings that the court will allow her to testify, but we're objecting for the record that any statements that she may have heard from RR are hearsay.
Okay, you're continuing. Your exception is noted. Thank you. All right, you may proceed, Mr. Jenkins.
Tell us what RR reported to you.
He first said he couldn't tell me, and I reassured him that he could. And he said, I can't. He said that he would hurt us, but he would blow us up. He was referring to JT at the time. And then he said that JT had a gun. And at that time, I asked him what it looked like to kind of confirm whether it was real or not. And he said that he saw the bullets, and I said, well, what color? And he said they were bullet colored. And at that point, he was crying, and I had RR come into my classroom.
And then once RR was in your classroom, did you place a call?
I did. I called the front office.
And what was the purpose of that call?
To report what RR had told me.
Okay. And who answered the phone?
Mr. Sims, our music teacher.
Okay. Thank you. If you could give me just a moment.
The music teacher's answering the front office phones? Sounds like we're going to be seeing Mr. Sims here soon.
I want to now fast forward a little bit and jump forward. Later in the day, did some students come running into your classroom?
Yes, I think it was just before 2 o'clock.
Hold on. Can you back up from that for a moment and just walk us through what happened that you observed or heard in the moments before students came into your classroom?
I heard a gunshot, and I immediately knew what it was. And I went to my classroom door and opened it. And Abby's students came running out, and I ushered them into my classroom. And I could see that Abby was standing. She had just exited her room. And I could tell that her hand was bloody, and there was blood on the floor. Once the last student that was on their way out came out, I shut my door and proceeded to lock down, turn off the lights, and settle the students.
In as much detail as you remember, can you describe the behaviors that you observed, the demeanor that you observed of the students as they came in?
They were terrified. Many of them crying. RR was situated behind me. I was sitting on the floor with the students around me. And he kept repeating, I told you. I tried to keep you safe. I told you. And I just kept reassuring. There were a few students who were trying to tell me what happened, but I didn't want my class that didn't witness it to hear all of the details. And I just kept reassuring them that we were okay.
Were some of the children were crying?
Yes.
All right. Ms. West, thank you for your testimony. I don't have any more questions for you right now. Please answer any questions from defense counsel.
Yes, sir.
All right. Good afternoon. How are you?
I'm okay.
I understand that you're upset, and that's reasonable. Whose student was RR? Was that your student?
No, that was Abby's student.
Okay. Did you have a relationship with RR? Or?
I try to have relationships with as many students as I can. So, yes.
Okay. And when you had contact with RR after recess, could you tell us again what prompted that?
What I was observing at recess was RR and JT kept going behind the rock wall, behind the tree, and I asked him to come tell me what was going on at recess.
Okay. Did you, during that recess time, did you believe that JT possessed a firearm?
I was not convinced until I spoke with RR.
Okay. So while the children were out on the recess, you did not feel a sense of danger or imminent harm to the children. Is that correct?
I don't really know how to answer that. We were kind of observing. I had been told that Dr. Parker had been made aware.
All right, I'm going to object to that statement.
Objection to that. If this is a question that he asked, and moreover, just a moment ago, he asked the question, what prompted her to talk to RR? And she's entitled to answer the questions that
he opened the door.
And so, again, we don't know what the answer is going to be, and it doesn't make it necessarily admissible. But that is hearsay that she was told. So at this point, we cannot consider that.
He's calling for it.
Another exception.
Thank you, Your Honor.
Next question.
He elicited the hearsay.
Based on your observations of RR, you weren't convinced that he possessed a firearm. Is that correct?
I was convinced they were hiding something.
Okay. Had you believed that he possessed a firearm, would you have taken steps to exclude him from the presence of the other students?
I'm not sure how to answer that.
All right, I'll ask it a different way. If a student possesses a firearm, should you take steps to exclude them from the presence of other students?
That's the administrator or security's job.
So, as a teacher, you don't feel like if a child possesses a gun, you should take steps to ensure the safety of those classmates?
If a child possesses a gun, I rely on the people whose job it is to check the child. And
I'm not talking about checking. I'm talking about protecting the other students.
I understand that. But it also could be protection of the other students by not exacerbating the situation.
Okay, so you're saying if a student possesses a firearm, it's better to leave that student in the presence of other students so the students won't become exasperated? Is that what you're saying?
No, I'm saying I would contact security and administration, and they will handle the student.
Okay, so you're essentially saying it's not your responsibility to protect the students.
That's not what I'm saying.
What you're saying is you're going to rely on somebody else to protect the students. Is that correct?
Sure.
Okay. All right. Did you have any conversations with Dr. Parker prior to the shooting?
Yes.
Okay.
It was, I don't know that I would call it a conversation. It was an interaction that lasted about 5 seconds.
Okay. Did you tell her that you believed that JT possessed a firearm?
No, that was prior to my conversation with RR.
Okay. Did you possess any means to communicate with the office while you were out on the playground?
Based on my notes, there was a walkie-talkie. I personally don't remember having it in my possession at recess. I even can't remember what the protocol was that year because they've changed so much. Sometimes there's one walkie-talkie per grade level. At this time, every teacher has a walkie-talkie. But I do not recall the specifics of the walkie-talkie that day.
So you don't remember if you had one or if Mrs. Warner had one? Or,
I do not know.
Okay. Do you remember if anybody, you or her, tried to make an attempt to contact the office while out on the playground?
No, I did not.
Okay, that's fine. So you didn't observe Dr. Parker's behavior or interactions anytime?
Personally, no.
Can I have a moment, Your Honor?
No further questions? What you got?
I'm sorry. So when I asked you the question about the walkie-talkie, I believe you indicated that when you looked at your notes, you saw that you indicated there was a walkie-talkie.
That I had one after recess. I do not remember the specifics of it before.
What do your notes say?
That I heard Mrs. Kovac on the walkie saying that she had the shooter.
Okay. I think so. That's all the questions I have, Your Honor.
Thank you, sir. Are you ready?
Yes, Your Honor.
Flying through the witnesses here.
At the time that you hear Ms. Kovac on the walkie-talkie, where are you?
In my classroom with mine and Abby's class.
Thank you. We know, as you testified, you were observing RR and JT at recess. Without telling me anything that anyone said to you, was your reason for observing them based on things you had heard from other faculty?
Yes.
Your Honor. Okay, one moment.
Objection. He's back to work trying to get in your city testimony. So, objection to yourself. He's basically asking, did somebody tell you that there was a problem, which is hearsay, and he's asking for a response.
I'm not. I'm asking for her reaction to receiving information. This is exactly the same in 100 cases where we have asked a police officer, did you receive information that caused you to go to such and such address?
Okay, but there was leading in there because you were leading her to a particular answer. So can you rephrase? I'm going to sustain that objection based on leading.
So, did you go to recess?
Yes. I was later than normal.
Okay. Was there a reason that you were observing JT and RR?
Yes. Two teachers told me that this is...
So, Judge, if I don't point the witness to something, that we're going to encounter this. So, we can't have it both ways.
Why can't you say without telling me the reason? Was there a reason?
Because the last time I tried to phrase the question that way, it was ruled leading. So I will rephrase the question.
He's so frustrated.
Ms. West, without telling me anything that anyone told you, what caused you to observe JT and RR at recess?
Okay, that was not a question that I stated would be the permissible question. So she's observing them, and I guess you're trying to listen. She's observing them based upon a reason. And then what would be the next question? When she says, I'm observing them based upon something somebody said to me, then what would be the next question?
That's the whole question. If she says, I'm observing him based on what someone said to me, I'm done. That's what I'm trying to get out of her. That's it.
Okay, so that my question, the proper question is, without telling me what was said to you, what was the reason that why were you observing him?
I think that's what I just said, but
Exactly
the judge has asked the question.
Okay, but you have the question, Ms. West.
Now I'm confused.
Okay. Was there a reason you were observing JT?
Yes.
Okay. And without making this word somebody said, what was the reason?
There was concern that JT had something that he shouldn't have.
Thank you, Judge.
Thank you, Judge.
Any recross?
That's all I wanted. That's what I asked.
Sure. So based on your observation, you did not conclude that there was a danger to the students from JT. Is that correct?
No, not at recess.
Okay.
It was following recess.
All right. And that was your concerns came to fruition after your conversations with RR.
Yes.
Okay. So there was nothing to prevent you from excluding JT from his classmates. Is that correct?
Nothing to prevent me from?
Yeah. You could have, if you perceived that there was a danger, you could have excluded him from his classmates. Is that correct?
But if I suspected what I had been told about, that could have made things worse.
Okay. Did you attempt to take RR to the office?
No, I called the office and reported what RR told me.
Okay. Did you attempt to take JT to the office?
I did not.
Okay.
My last interaction.
Okay. Did you yourself attempt to contact the police about your concerns?
No, I called the office.
Okay. That's all the questions I have.
Anything further for this witness?
No, Your Honor.
And status of Ms. West as the witness?
I'd ask that she remain subject to recall, constructively sequestered.
Same.
Okay. So Ms. West, you are still a witness. You are still sequestered. You may not discuss this case until this trial is over. But you do not have to remain in the building. You do not have to remain in the witness room. You are free to go about your daily life. And if you get a phone call that you need to come back to give further testimony, please come back. All right. Thank you, ma'am. You may step in. Thank you. All right. Next witness.
Your Honor, I'm going to ask that we take a break, and there is something that we need to discuss with the court.
All right, and it's been about an hour, which is a good wake-up stretch break after lunch. So we'll ask the jurors kindly to retire to the jury room while we take up a motion.
All right, I'm just going to make sure that they leave and we don't have any loud noises like we just had right there that I just cut off. Great. Well, we're getting ready to take up the motion. Hopefully we get to hear this part.
Remember in the beginning when we started 110 years ago?
Wait for it. Long break, long break. And be back here in just a second. I think this motion was taken up off the record, so didn't get to hear any of it.
Your Honor, I prefer to go ahead and take up the whole matter at once.
So deal with it tomorrow?
Yes, ma'am.
Okay, so we'll start at 8:30, not 8 a.m. With that being said, how much time do you think that's going to take? And let's try to do any other motions and objections so we can get rolling. So do I ask the jury to come at 9 or 9:30?
I'm going to have our witness that would authenticate that video be here at 8:30.
Oh, yes,
so
sir.
we could get going on dealing with the admissibility of
early.
it right at 8:30.
Okay.
You want to say 9:30? Just.
I'm pushing.
Okay, well, 9:15. Okay. Well,
Okay, so we'll resume the judicial proceedings at 8:30.
First day's over.
To take up the anticipated objection. I will ask the jurors to report at 9. Usually it still takes about 5 to 10 extra minutes to go from that to actually in the box and ready to go. All right. Anything else we need to address today?
No, Your Honor. Thank you.
Okay. And then Sheriff will let the jurors know that they are adjourned for today. I'll go back and, let me bring them out to give them the reminder of sequestration, just on the record. Okay, thank you, Sheriff. Bring the jurors out, and everybody please stand as the jurors come out.
All right, we don't need to listen to the judge sequester the jury, or just remind them not to do anything on the jury. We now can jump to today's happenings in this court, which start bright and early. Now we're on day 2, part 1, or this is the live portion of trial. So let's see if we can listen to that. As we're coming in, just 1 second, make sure this is correct. It's looking good. All right. Catching up. We're catching up.
Yes, good morning. Yes, sir. Please approach.
Just need to request a new battery in this microphone. Judge says, that's great. I've got a drawer of them right up here. Got up here. I'll give you a new 9-volt. And just kidding. That's actually the pool TV cameraman changing the wireless microphone. I'm going to turn the sound off here for a minute because when he plugs it back in, it might go pop. Got a call coming. I'm not sure who it is. Hang on 1 second. And they hung up. We have audio again. Judge has a fancy little collar on. Looks all blingy. Starting day 2 at 44 objections. Not bad for the first day. Donnie, not Wahlberg. Flow state. I don't know what that means. Somebody explain it to me. I don't mind if she gets involved, but she just has to make legal rulings that, conform with law. I just now noticed the blue lamp next to the judge. I know that's probably the brightest thing on the screen.
Good morning to all parties. We are now ready to resume day 3 of Commonwealth versus Ebony Parker. For the record, the Commonwealth attorney is present with paralegal Ms. May. Good morning to you both.
Good morning, Your Honor.
We have defense counsel present, Mr. Rogers and Mr. T.
Good morning, Your Honor.
Good morning to you
Mr.
both.
T.
And we have the defendant, Ms. Ebony Parker, present at counsel table with attorney. The jury has not been brought out. I believe we had an objection motion to take up and 2 matters with jurors that we needed to address. And anything else that you all would like to address before we bring out the jurors? Yes, Mr. James.
Your Honor, as to I think the court stated as the objection, I would ask that the efficient way to handle this is for it to be the Commonwealth's motion in limine to admit certain evidence. And there will be 3 things outside the presence of the jury that I'll seek to establish are admissible with 1 witness, Dr. Parrish, who is here. The 3 things that I'll seek to establish that are admissible are parts of the Newport News School District Handbook, parts of the Rich Neck Crisis Management Plan, and a video interview that Dr. Parrish did with the defendant. And so would court and counsel like to proceed on that matter first?
All right, and then Dr. Parrish, are we saying P as in Paul?
F-A-R-R-I-S-H. Yes, sir.
I can tell you, no stipulations here. These 2 are not on the same page. Imagine these are going to be hotly contested.
Okay, defense response.
Your Honor, of course, as the court has prevented me from making motions
What?
Post or previous days to do that. He's going to try to get these documents in. I'm going to obviously be objecting to them coming in. I really don't have a problem fleshing that out before we get before the jury.
Okay. And so I guess the defense response is all motions in limine and things of that matter were to be handled in a pretrial fashion. And we had several dates prior to the scheduling of this trial to deal with those matters. Why are we dealing with it now?
Good question, Judge.
Because the defense is objecting, and I must lay a foundation for two exceptions to be met. And those exceptions would be the public documents exception and the business records exception. And those are evidentiary issues that without an objection, I would never have known to file a motion in limine on. So they had to tell me they were objecting to those business records.
Okay, and to the business records, and the other exception was?
The two exceptions that apply to the documents, I think both exceptions apply, are the public documents exception and the business records exception. And of course, I'll provide more detail on that if the court wants me to go ahead with the motion as a motion in limine.
And to the three things you would like to introduce into evidence, do the two exceptions apply equally to all three?
No. As to the video, it is a statement of a party opponent. It is an interview of the defendant by the witness who I will have here on the stand.
That's coming in.
The business records and public documents exceptions, I wouldn't seek to apply to the video, but I would seek to apply to the policies of Richmond.
All right, thank you. All right, to Mr. Rogers.
Can't believe he's fighting
what
these.
What is your position that they're seeking to introduce it?
Your Honor, of course, I would have liked to have seen this motion in writing so that I could properly respond to each of those stated.
You objected.
They think that applies to this.
He responded.
Documents, so that I would be able to have statutes and case law to defend against.
There's no case law for that.
Regarding Mrs. Parrish's testimony, her testimony is going to be her testimony. I believe the Commonwealth is going to have a problem authenticating the video, so she can testify as to what she saw and observed. But regarding the playing of the video, we're going to be objecting on an authentication basis.
Okay, so let's break this down. Two, portion of the Newport News Public School Handbook, which Commonwealth is seeking to introduce. Let's not call this a motion in limine, but they're seeking to introduce it. What's your position to that?
Your Honor, my objection is going to be it's hearsay. It's going to be offered for the truth of the matter. So.
Okay, so let's deal with that. So the hearsay, and Commonwealth has already responded that they believe it falls into the exception of public documents and business records. What's your position?
My position is it does not. It's not a public record. It's a internal document that governs the policy of the Newport News school system. And regarding a business record, if I could just look at
yes, please. Okay, and let me pull out my rules book.
The judge says, "Let me get not case law, but let me get my old law manual, the rules book."
And Ms. James, if you could point me to this section in the rules of the Supreme Court.
Your Honor, I have several citations that relate to the admissibility of this, and I'll have to lay a foundation with Dr. Parrish to meet the requirements, but I'll be happy to.
Okay, I'm still at the Newport News Public School Handbook. That's what you're referring to?
Yes, Your Honor.
Okay, but give me just the public documents hearsay exception, statute and or rules number and business records.
Yes, Your Honor. Both the public documents and business records exceptions are codified under Virginia Supreme Court Rule 2803.
I guess juvenile court and family law didn't have many objections on this grounds, I guess, because she's learning it for the first time right here, asking the attorneys arguing before her, what are the rules on this and where can I find those? I'm not sure if Rob from Law and Lumber could weigh in on this. This is too close to his neck of the woods. You don't pee in your own swimming pool, right? It's just a general advice for you.
In reading the public records and reports section of Rule 2:803, paragraph 8, public records and reports. In addition to categories of government records made admissible by statute, records, reports, statements, or data compilations in any form prepared by public offices or agencies setting forth A, the activities of the office or agency, or B, matters observed within the scope of the office or agency's duties as to which the source of the recorded information could testify, if called as a witness, generally excluding, however, in criminal cases, matters observed by police officers and other law enforcement personnel when offered against a criminal defendant.
Lady Dracona, it's good to have you here. We missed Rob.
And business records, Ms. Jenkins, are you going under 6 in records of a regularly conducted activity?
Let me check the numbers.
Their policies are on the internet. Camilla just found them from Brazil, right? From Brazil.
Yes, Your Honor.
And reading that, so saying section Rule 2:803, paragraph 6, records of a regularly conducted activity. A record of acts, events, calculations, or conditions if, paragraph A, the record was made at or near the time of the acts, events, calculations, or conditions by, or from information transmitted by someone with knowledge, paragraph B. The record was made and kept in the course of a regularly conducted activity of a business, organization, occupation, or calling, whether or not for profit. Paragraph C, making and keeping the record was a regular practice of that activity. Paragraph D, all these conditions are shown by the testimony of the custodian or another qualified witness, or by a certification that complies with Rule 2:902, paragraph 6, or with a statute permitting certification. And paragraph E, neither the source of information nor the method or circumstances of preparation indicate a lack of trustworthiness. Okay. All right, so again, we're back with parts of the new school handbook. Commonweal seeking to introduce them, defense is objecting. Would the defense like to flesh out their objection?
Your Honor, I'll start with the records of a regularly conducted activity. I would say that those handbooks are definitely not those. This contemplates records that are basically prepared from day to day, indicating the daily activities, the business transactions of that business. That's not what we have here. We have basically a policies and procedures book. A says the record was made at or near the time of the acts, events, calculations, or conditions. That's definitely not met. So the record was made and kept in the course of regularly conducted activities of the business. Your Honor, these are one-time documents that gets produced once or once a year, maybe once every couple of years.
I'm with him on that.
Making and keeping of the record was a regular practice of that activity. This isn't a record. This is a policy and procedure handbook.
It's a public document.
It doesn't qualify as the records of a regularly conducted activity.
It's a public document.
So all of those conditions have to be met, which is encapsulated in paragraph D.
Okay, and with respect to paragraph 8, public records and reports.
All right. Regarding the public records and reports, I would submit that policies and procedures handbook is not an exception based on a statute made admissible by statute, and it's not a record or report or a statement or data compilation. So
I would submit that it doesn't qualify under that paragraph either.
Okay. Anything further from the Commonwealth?
Yes, Your Honor.
And again, we're going one by one.
Okay. So with respect to the manual being a business record, I'll start with that one. I'll ask the court to rely on the case of Carmody v. F.W. Woolworth. Carmody is C-A-R-M-O-D-Y.
Brings the case law.
V. F.W. Woolworth, W-O-O-L-W-O-R-T-H Company. It is 234 VA 198. In that case, an employer's employee manual was admitted under the business records exception to prove what a particular employee's duties were, and the court held that it was properly admitted under the business records exception. And so that case establishes a business records exception, and the Supreme Court has said that an employee manual, if kept in the regular course of that business, is admissible under that exception. I'll turn to the exception for public records as well. Actually, Judge, as to public records, give me just one moment.
Yes, sir.
They're literally on their website.
As to public records with the school handbook, the policy handbook, it is a report prepared by a public official, that being the school board, pursuant to the nature of their office. So it requires that they, by nature of their office, produce policies that relate to the schools under their direction. And given that, it's admissible under Williams v. Commonwealth, that's 213 VA 45, 1972, among 3 or 4 other cases about public documents. I will have a different argument on that related to the crisis management thing.
Yes, sir. Anything further as to the Newport Public School Handbook?
Right, could I have just a moment to look at that Williams v. Commonwealth?
Yes, sir.
We're all getting a little smarter today. Some of us more than others. It's gonna head us down to the courthouse and get educated. Yeah. Laura, I hear you. The goats are going to run out of batteries on this one. We have to be judicial in our use of their scream. Can you imagine if the parents didn't have access to this? They had no idea what the school policies were. They're probably given a copy of these when they're rolling a student. Ooh, threw the doubler on. Threw the doubler on, went for the sharp focus, missed it. Tried again, missed it yet again. The doubler sometimes can mess with the focus just a little bit. So throwing on the doubler, what they did, which is basically right there, and they just took it off.
35.
can mess up the
I cited
focus.
a couple of different cases. Are you
The last one.
Williams v. Commonwealth is 213 VA 45.
In an effort to save my sanity while they have been arguing over these basic legal principles, I'm shopping for a pellet mill on Amazon. I don't have a rabbit, a horse, a chicken, duck, or even fish to feed pellets to, but for some reason I'm fascinated with how they operate. I'm not going to buy one, but in case you want to make rabbit food, there's a machine for that. Okay, the doubler thing needs to go. So you gotta pick a lens and stick with it.
I'm not sure if the court has had a chance to pull up that case.
Yes, sir.
Okay. So it really does not support the Commonwealth's position. It's
what?
It is a case where the Commonwealth is attempting to get in information from the Central Criminal Records Exchange, and it's the rule that it's referring to. It says it is generally recognized. It is a generally recognized rule that records and reports are prepared by public officials pursuant to a duty imposed by statute or required by the nature of their offices or municipal as proof of the facts therein. It goes on to say, but the mere fact that a record or report qualifies as a public document does not automatically overcome the state protection.
Mr. Rogers. Talking too fast for the man court.
I'm sorry. Unless the document relates facts or events within the personal knowledge and observation of the recording official to which he can testify should he be called at trial. That's not what we have here. So
that's exactly what we have here.
Does not support the Commonwealth's position.
Thank you. So regarding the Newport News School Handbook.
I'm sorry.
Yes, sir.
Mr. T was reminding me in the very first case, it's a civil case and it's not a criminal case, so it doesn't apply.
Thank you. So the hearsay exception of public records and report does apply to the Newport News Public School Handbook. And we can distinguish the cases as Williams refers to the CCRE, which is a criminal record database and history, again, which is a different public record. And again, there are exceptions for public records compiled by law enforcement. And then again, defense has already distinguished the civil case. But this clearly falls within the statute as a permissible exception to hearsay. So the Newport News Public School Handbook comes in.
Yep.
Now, the Enrichment Crisis Management Book. Can you first explain to me what this is? I don't know. I need more understanding.
Yes, I can proffer that if the court wants. Dr. Farish is here and knows more than I do. But the Crisis Management Plan is a document that the school board is directed to require individual schools to create and to update annually. This comes from Virginia Code 22.1-279.8D, where the school board is required to ensure that every school in the district produces a crisis management plan, reviews it annually no later than August 31st, and then the school board certifies in writing to the Virginia Center for School and Campus Safety that annual review has been done each year. So it is a report, it is a plan required by statute. The contents of the plan generally is it outlines how faculty are to respond, and employees, faculty and employees, are to respond to all various manner of crises that could occur in a school building. Not just violence, but just any sort of crisis, a fire, a natural disaster is covered. Many things are covered.
Are there scenarios that are factually close to the facts reported, in this case, covered in the crisis management book?
Specifically in the crisis management book, there are instructions both on what to do if a suspected weapon is in the building and what to do if an armed student may be in the building.
Okay.
And let me just add, Judge, exactly in both of these documents that I'm seeking to admit, my plan is to just admit the portions I believe are relevant via the testimony. And I wouldn't even seek to introduce the entire document. However, if the defense wishes for completeness to introduce the whole document, I would not object to that either.
Okay, and then you said you had additional argument on why this is admissible. If you'd like to go into that now so that they can get their cases together and be ready to respond.
Yes, Your Honor. For the crisis management plan, the strongest argument for its admissibility is the public documents exception. And that's because they are required to do it by statute, and that's one of the requirements of the public documents exception, is that either it be required by the nature of the duty or it be required by a statute. And here it is required by a statute. That statute is 22.1-279.8D, where the creation of the management plan and its annual updating is required by law. Given that, it qualifies as a public document, and we should be able to authenticate it by use of the custodian of records who is here. It is also a business record, I believe, Judge, for the same reasons that the manual is a business record, but I believe the stronger grounds for its admission is the public documents exception.
Thank you, sir.
These better both come in.
Yes, Mr. D.
Your Honor, regarding the handbook and this, the manual that was just referenced by the Commonwealth, the issue with these documents coming in is that it's going to be very dangerous and it can confuse the jury. This is a criminal case. The handbook and the manual cannot set the criminal standard here. They're containing, as the Commonwealth has stated, there's a plan in place for what is supposed to happen in certain situations. I believe that the jury may confuse that with the criminal standard.
You don't get the sword and shield.
It's not a civil case. The criminal case, the criminal standard is much higher than any, and it's not governed by the Newport News Public Schools handbooks or manuals. So while they may be relevant to the standard of care by an employee, they cannot be used in the analysis of criminal culpability.
You might have an argument on part of that, but they're using the other side as a sword.
And the handbook supports that we're not present at the Richland Elementary School that day. In the manuals, it contemplates that there's a school resource officer in the building. That is not present here. So there are supports in those manuals and handbooks that are assumed that are not present in this case. So we object to the admission of both.
May I respond briefly, Judge?
Yes, sir.
The arguments of counsel just now are fair arguments for him to make as to the weight of this evidence, but those arguments don't go to admissibility. The admissibility is defined by the rule and the case law, and I understand counsel's position that there's little relevance is what it sounds like, but there's certainly enough relevance that it should be admitted, and that argument that we just heard could be made to the jury.
So, in respect to the Richland Crisis Management Manual, the court does find that it qualifies under the hearsay exception of public records and reports. Now, I will say there, because it is required by statute, doesn't make it admissible by statute, but it meets all other requirements of the public records and reports. And just for parties' edification, I do not find that these will qualify neither the public school handbook or crisis management manual under the records of a regularly conducted activity, as it has to be established that it was made at or near the time of the act or events or calculation. Annual manuals are different from a receipt, a purchase receipt. That's time can't say I bought this item then, which is a business record made at or near the time of events. that had not been established. So it would not come under that exception, but it does come under the other exception. All right, the third matter is the interview with Dr. Farish, a video interview. Now, I don't know what this is. I don't know what it's purporting to put in evidence. I don't know when it was recorded. So if you could proffer to me some of that, and then we'll get into why you believe it's admissible and why they're objecting.
This is going to be
Yes,
good.
Your Honor, the video was recorded as part of an internal school investigation by Newport News Public Schools Human Resources. The interview was conducted over Zoom. On the recording of the Zoom, you can see that Dr. Nina Farish from Newport News Public Schools, the HR director, is asking questions of the defendant, Dr. Ebony Parker. The video, I don't remember its total length, but in the video, the HR director is asking several open-ended questions about the incident at Rich Neck Elementary, and Dr. Parker is answering those questions about the incident.
Okay, and do we know the date or when was that taken in relation to the incident, to January 6th?
Doesn't matter.
Was it 2023?
I mean,
Your Honor, if I could have just a moment to look that up, I think I can find it.
if she's made statements about the occurrence, obviously it happened at the time or after, and it's fair game. This is a statement by party opponent. We've seen jail phone calls from the week before trial brought in. Statement by party opponent. I look forward to singing happy birthday to this judge as she celebrates her 1 year on the bench this August. It's going to be great. I think she's got a great career ahead of her. She's making some good rulings. We've been a little hard on her at the beginning here. This is not juvenile and family court that she's used to. She's stepped up to the big leagues here, and this is a big, big case. The 45 minutes we just spent on that, on ruling whether or not the business records, the employee plan that the defense has been using to beat on the teachers and throw them under the bus, saying, you had the authority, you should have done more. They're now saying, you can't use that against our client. Prosecution says, we'd like to introduce that plan, that emergency plan, and the manual, the employee manual, into the record so the jury knows what tools the teachers had at their disposal and what they didn't. The defense is saying, we don't want that in. We want to say,
Your Honor,
use it as a sword, but also as a shield.
Myself is that the the HR director was assigned to do this report and began her investigation on January 9 of 2023. As to what day she interviewed the defendant, I don't know, but she is here, and I'll be happy to have her testify to that fact.
Okay, if we need to get to that part. And you believe this is admissible, you said, under
statement by party opponent.
admission by a party opponent?
Yes, exactly as any criminal defendant's statements or confessions would be admissible. It's both a party opponent, and a statement against interest.
Okay. All right, and let me read those into the record.
It's both.
So, again, under Rule 2:803, paragraph 0, admission by party opponent. A statement offered against a party that is, A, the party's own statement in either an individual or representative capacity, or B, a statement of which the party has manifested adoption or belief in its truth, or C, a statement by a person authorized by the party to make a statement concerning the subject, or D, a statement by the party's agent or employee made during the term of the agency or employment concerning a matter within the scope of such agency or employment, or E, a statement by a co-conspirator of a party during the course and in furtherance of the conspiracy.
A, Judge. The correct answer is A. You can phone a friend if you want, but
give me the second one, Mr. Jenkins. What paragraph am I looking for?
Statement against interest.
Judge, I called it a statement against interest, but I think that really is encapsulated in the Virginia rules as an admission.
Okay, yes, the other one has to deal with property only.
Yes.
Okay, all right. Okay, all right, defense.
Your Honor, regarding the statements that my client has made. There's really no reason to object to any of her statements. Again, the problem that we're having is the video, authenticating the video. If Ms. Ferris testifies, that's her statement that my client made. Can't object to that coming in. But as far as playing the video without proper authentication, then we
Okay, understood. And all of these are still subject to all of the other rules of evidence, especially regarding authentication. But we were just trying to get those out of the way. Okay, so then for the interview with Dr. Farish. Again, assuming it meets other admissibility requirements by law, it comes in. All right. Anything else we need to take up other than the juror issues?
Yes. Your Honor, can you just direct the defense to stipulate to something where they literally say, regarding the statements my client made?
Mr. Teague has also advised me that we definitely have concerns regarding the actual interview, the coercive nature of the interview, that setting in whether my client felt like she had a right to not give those statements. Rather, we definitely believe that as far as the video is concerned, playing that before the jury would have a profound prejudicial impact on the jury. And we would ask that even though it's relevant, that the court exclude it based on the prejudicial nature of the statement.
Okay. And did you receive this in discovery?
I did.
Okay, why didn't we deal with that in a pre-trial motion?
I'll submit.
I'll submit. Okay, we'll
Maybe
clock those big
the
three.
record, but it is going to be allowed in. Okay, so we have two juror issues. I'm sorry, go ahead, Mr.
What?
Rogers.
You say it's going to be, her statement's going to be allowed in, but at this point...
Again, it still has to meet other rules of admissibility. Okay. But in terms of you saying that she didn't have counsel, she didn't know that she didn't have to participate, those things could have been done prior to trial and were ordered to be done prior to trial, and they were not. So I'm not considering anything else regarding that. Now, we had one juror state she had a question, and we had one juror indicate he would like some clarity regarding objections to stricken evidence. My position was to have the juror who had the question write it down with the juror number, and we read it out here on the record, and then I'll ask attorneys how they want us to respond to it. Do you all prefer to proceed in a different format?
That's fine for the common room.
The judge doesn't have a plan for juror questions.
Okay. And again, they are not to be deliberating. So, do you want to have just that one juror brought out here and write the question down so that it's not in front of the other jurors, or do you want the question asked in front of all of the jurors, or just pass us a sheet of paper?
I'll defer to the defense on how they want that to go.
Your Honor, we have no problem with her just writing it down, not being viewed by the other jury members, and then read by Your Honor.
Okay, so Sheriff's object, and I don't know her juror number, but it was the young lady who sat in the first row far left. If we could have her write down, I'm asking her to give me a sheet of paper with her juror number and to write down her question and fold it out so that the other jurors can't see it, and we'll bring it out here and read it on the record. Thank you very much.
No problem. All right, are you going to step off, Judge? What's the plan? We're waiting for a juror question now. Delicious. Oh, man.
While that is happening, we did receive several media requests for copies of Commonwealth 1, the video being played, and it has not been sealed to this point. The parties have a position to that. So that would have been the video of Ms. Kovac having JT in a bear hug, which was not played, but I just want the parties to know the media is asking for it. As of now, it's open and not sealed.
Judge, I would ask to seal it because a minor is depicted in the video.
That's it. I just want to know your position.
Your Honor, I support the Commonwealth's position.
Okay. So Commonwealth 1 will be marked sealed.
That's the right move. I know we like to see everything, but that is the correct move.
But I will let downstairs know.
But I should also say it should have been released if it was filed and not sealed. I know that goes against each other. Nobody did their homework. Oh, man. I've got to give this judge some
Juror
latitude.
number 38.
She's new.
What is written on this paper reads as follows. What are the 8 felony counts? The time from recess to shooting? Did VP make 911 call? How would parties like the court to respond?
Don't respond.
And I'm happy to pass. Sheriff, you can pass that down. They can each see the sheet.
I believe that the court should instruct that jury members are going to have to rely on their memory of what they perceived the evidence was.
I think that's true, but I think also that they have to rely on their memory, and because the trial is still ongoing, that they have to rely on their memory and any evidence the court admits during the course of the trial.
Okay, and again, the court concurs, so that juror will be instructed to rely on their recollection, but wait till the conclusion of all evidence. There will be more evidence presented, and to not start deliberation until the case is given to them. So, yes, Mr.
On that point, Judge, I feel like it is incumbent on us to voir dire the jury members, both based on her question and the gentleman's question as well.
Yes, the gentleman, absolutely. But you want to voir dire her as well regarding
my goodness.
If she's spoken about this with other jurors?
Yep.
Yes, only for that limited purpose, whether she's spoken about it with other jurors. I certainly don't want to ask any questions about these 3 things she mentioned.
Okay. Defense position, if any.
I agree that she definitely needs to be brought here.
Bring out the juror.
So that we have a game plan for when she comes out here. We're just going to keep it to are these her questions alone? Has she discussed any of the case with other jurors?
Yes, and I would submit that the court can do the inquiry without us.
I just want to be, okay.
Yeah, keep it neutral.
And I would ask that the court inquire, has she observed any other jury members discussing anything pertinent to the trial?
Use her as a spy.
Okay, thank you. Okay, so Sheriff, if you can bring out just juror number 38, please. Yes, sir.
Here we go. Here we go.
Marshall come out again. I don't know who the gentleman was, his number yet, but absolutely we will voir dire him individually for the basis of his question.
Oh man, I need to find some copyright-free circus music to play in the background here because this This is just crazy. This is wild. This is everywhere. It's all over the place. We're now under the big tent with the elephants and the lions and tigers and the trapeze artists. Here we go.
Good morning. Yeah, you can have a seat in the jury box. Thank you. Good morning to you.
Good morning.
Okay. And I do want to remind you, of course, you're not being recorded. You're not on video. You can have a seat.
Oh, yes, you are.
Your face and information will not be displayed to the media. Okay, so first, I did receive the answer to your questions, and I have 2 responses. And my responses are required by law. One, you have to rely on your recollection of what the evidence is. And 2, evidence is still being presented to you. So please don't make decisions or deliberations until the case is given to you for deliberation, and that would be at the conclusion of all of the evidence. And I can't, you have to rely on your recollection because the court doesn't want to give undue weight or influence or suggestion to any one piece of evidence over the other. That's why I'm not answering your specific questions.
Having said that,
I don't mean to be rude or disrespectful.
We have some questions for you.
You have to rely on your recollection. So now, we had one question for you, or maybe 2 questions. Are these your questions alone, or have you discussed this with other jurors?
No, my questions alone. Like yesterday, we had it, and it was like, and I guess I missed some of that information when it was given because I wasn't writing everything down. I wanted to listen to everything that was going on. So I may have missed if those answers to some of that.
Okay, understood. And have you observed any of the jurors discussing the case? Because they are not supposed to discuss the case until it's given to them for deliberations.
No.
All right. Thank you, juror number 38. One moment. Let me see if the attorneys have any follow-up.
Nope.
I don't. I think of it.
Okay. All right. Thank you very much. Yeah, you can go back to the room, and we have one more thing to do, and then we'll get started with
don't tell them what we asked you. Don't let them know you're the spy.
The gentleman in the back row far right, you know who it is? Oh. Okay, yes, so bring him out. I don't know his number.
Okay, here we go. Oh, man. Yeah, this is.
Good morning, sir. You're welcome to have a seat. Thank you very much. And if you can give me your juror number.
Juror 33.
Thank you, juror number 33. All right. And again, I do want to remind you, your face is not being filmed, and your information will not be released to the press. Okay. Yesterday, you had a question, and so we would like to hear your question, and then we'll decide how to respond. And then we may have a question for you. So yes, sir, juror number 33, what was your question?
In this case so far, there have been a number of objections and information we've been told to omit from our consideration. In the event that while we are taking our notes and trying to recall information, we are unclear about what information is to be omitted, are we allowed to ask for clarification from what point in the witness testimony or from what point in conversation we are to omit from?
Okay.
He's like...
and I'm now going to turn to the attorneys. My position is by law that we...
How do I unring this bell?
Response of you have to rely on your recollection as best as you can. Does Commonwealth wish a different response?
No, not on that issue, Judge.
Does the defense wish a different response? And I do understand we're going to ask some other questions about the we part. But Mr. Rogers, just to... Can the court clarify the objections and what was stricken and not stricken?
I don't have a problem with the court clarifying.
Okay.
As it did before.
What, giving the same response or offering clarity? Giving the response that he has to reply, the jurors have to rely on their independent recollection.
That satisfies the defense.
This is in front of the juror.
Yes, Your Honor, I think my clarification that not only do they rely on their own recollection, but again, to instruct them that anything that you have ruled that should be stricken or should not be taken into account, should be just done just so, considered or handled just so. They cannot consider it.
Okay.
Yeah, but what is that?
So, juror number 33, and that is the response that the court is required to give by law, is that the jurors have to rely on their independent recollection of what the evidence is, and they cannot consider something that's stricken. Now, I understand your point. Well, what if I don't remember what was struck or not, and I got confused in the sustained, overruled? You can consider this. You
do what
cannot.
you think is best.
Again, you have to rely upon your recollection as best you can. The fundamental principles in the Supreme Court law regarding that are that I don't want to. They frown upon the court giving emphasis to certain evidence over another. So that's why we don't try to verify. You have to receive it and make your best judgment. Because if I point it out for you, that can give it undue weight. Now, you use the word "we" several times. Why do you use the word "we" and are you discussing that? Have other jurors expressed the same confusion?
The other jurors have not expressed that confusion to me. I posed that question to the other jurors and none had an answer.
Okay. And other than that question being posed to other jurors, have they discussed the case? Are you observing anyone discuss the case?
No, ma'am.
Okay. And the reason why I ask is because you're not to discuss the case, which is deliberate, until it's formally given to you at the conclusion of evidence. So there have been no discussions about the case?
No, ma'am.
Okay. All right. I'm going to turn to the attorneys to see if they have additional questions for you.
Understood.
All right.
We don't have another question.
Okay. Mr. Jacobs.
I don't have any questions.
Okay. Thank you, juror number 38. You can retire to the room. We have one more thing to take up, and then we'll start the case.
Quick correction, Judge.
You have a question?
No, quick correction. Just now, we referred to him, the court referred to him as 38.
No, 33. Thank you. 33. Juror number 33. I'm sorry. Thank you. You can retire to the room, please. Anything that
He
someone
asked
would
the
like
other
to
jurors, but they wouldn't
address
respond.
before we Bring the jury out.
Your Honor, can I just step out for a quick minute? I'll be right back.
Yes, sir.
Defense runs to the little lawyer's room again. That's all right. No shame there. Better you make a quick pit stop than a quick clothing change. So. She gone. She gone. I don't know where she went.
I'll give you that. Keep receipts.
No, we can't. You leave. She leaves the bench. We have to turn it off. Them's are the rules. All right. So what happened there? The first juror had 3 questions, basically about evidence. How long did the assistant principal call the police? Did she call 911? I think questions about the evidence. And the judge said, we can't tell you that. You have to rely on your recollection. But by the way, did you talk to anyone else about it? She said, no, it's just me. They said, good, go back to the juror and bring the other juror out. He had a question last night, and the question was, hey, when you say to disregard something because, it's been stricken from the record, what if we can't remember what part you're talking about? I mean, we've been keeping notes furiously, and obviously these arguments are happening in front of the jury. These are speaking objections. There are no sidebars. They're happening in front of the jury. And so they've probably got a page and a half of notes since the original objection was made, and then the judge comes back with, strike that last question, and they're like, where was it again, Your Honor? Was that before or after you had to look up the definition of the word hearsay? I'm so confused. Help me understand when. And she said, just do your best, honey. And juror number 33 has asked the other jurors. That's the problem. When he asked the other jurors a question, you have to be very careful there. Now, he wasn't deliberating, so he's fine. He's not going to be kicked off yet. But it's like problematic that he's like willing to talk about things about the case to the jury or approach that area. So the jury's lost. They have no idea what the evidence is, A, and they have no idea what all that they're supposed to strike from the record, from their memory, B, and the judge doesn't have a plan for jury questions. Like, she doesn't. I don't know if she knows if she allows them or not. Like, this may have never come up before. I don't know if she's handled a criminal trial with a jury before, or if this is her first one. But I mean, with she started in August on the bench here doing criminal trials or criminal caseload, and it's starting to just bloom out of control. As she's doing a good job with some rulings today. I think she's really following the prosecutor's lead, which I like, because I think the prosecutor is accurate from a legal standpoint. Obviously, the defense is not going to like that at all if she's basically following the footsteps the prosecution lays for her. She needs to rule on her own and instead of just parrot the answers the prosecution gives. But prosecution's just giving the case law and the law to the judge, because she doesn't know it or she isn't familiar with it. This is crazy for that reason. Oh, man. It is an insane way to run a courtroom. I think she'll get better. I really do. I have high hopes for this judge. And I'm glad my first time driving a car, my very first time I drove a car, was not televised for all your enjoyment. Because I was not the best driver. I probably made a few mistakes. I probably neglected to look in the rearview mirror ever.
Anything in addition to his report? Any comment on his responses?
Yeah, sure. Regarding juror number 33, I think what's most telling is what the juror stated while he was not being asked direct questions about whether they've discussed the issue or discussed the case. Several times he used the word "we," indicating that there had been deliberating or discussion of the case between the jurors. He stated that he asked a question about the objections and what they're to consider and what they're not to consider. And nobody could give the answer to that question. That indicates that there was discussion about the issue that he raised with the court. Moreover, the issue or the questions raised by juror number,
was that the young lady?
Yeah.
38. She's 38.
38. Your Honor, frankly, I think those questions were improper and have, kind of aided the Commonwealth with knowing what is important to the jury in real time as the trial is going on,
and
allowing them to potentially shape their ongoing examinations of their witnesses. And so, Your Honor, for that reason,
same for you.
We believe that we're making a motion for a mistrial.
Ask for the mistrial. The big M. The big M.
Can I just move?
Yes, sir.
Your Honor, this isn't going well for us. We're going to go ahead and just ask for a motion for mistrial because one juror has questions. We didn't answer those questions, but the fact that she told us what the questions were, now the other side can cheat and answer those questions. Well, so could you, sir. If the answers, on the other hand, are not beneficial to your client, which in this case I don't believe they are, I think they should have instead asked to strike that individual juror instead of a whole mistrial. Said it's clear she's deliberating in her head as she's forming questions instead of just listening to evidence. That would have been a better argument to make instead of going for the big M and nuke the whole
respect to the issue with number 33, sort of announcing this question to the panel, I share the defense's concerns about that. It sounds to me like the question almost suggested to them that they should be confused about it and started to start them reasoning over the evidence. So I share their concerns about 33. I don't share the concerns about 38 that were mentioned because I can't change what my evidence is based on what they asked.
Like I couldn't suddenly admit a 911 call because no 911 call was provided in discovery. You wouldn't be allowed to do that, for example. However, and while I know number 38, I feel like number 38 has, begun to form conclusions in her mind about the case as well. And given that, I think I have to agree with the defense's motion.
The motion for a mistrial? What?
I will recess to consider this.
What?
And we also have 2 alternates. So we could release jurors 33 and 38 and still have 12 jurors. But I do understand your concern that, again, let's parse this up. Jurors 38 were her questions alone and were not shared or disseminated with the other parties. So if there are concerns about Juror 38's questions, Juror 38 could be released as an alternate and we still have a constitutional jury panel. Juror 33 did ask his questions of the other jurors, and we're all grateful the other jurors didn't respond and followed the cautionary instructions that the court did give not to deliberate until this case is given to you for deliberation. And now, let me add to this. The sheriff has indicated Juror 33, the gentleman does have a notepad back there that was not a notepad court issued, but we don't know what's in the notepad.
Take his notepad.
Let's bring him back out again and see what's in the notepad.
Oh my goodness.
Well, hold on, Sheriff. Yes, Mr. T.
Just for the record, Your Honor, regarding juror number 33, his testimony, from what I recall, was not that they did not answer him. He said that they didn't have.
Oh, they said they did. They're right. They didn't know.
Right. So there's, to me, that indicates.
So let's follow up on that. Yeah. Okay, bring out juror number 33 again, please.
That deserves a triple goat scream.
Okay, and you can have a seat, juror number 33.
Thank you, ma'am.
Okay, 2 questions of clarification.
Absolutely.
I do understand you said you asked your questions of the other jurors, and if you could give me the detailed verbatim responses you received, whether it was they did not answer you or they said words, if you could give me the actual, your recollection of those conversations, and with how many jurors?
My recollection of the conversation was when I posed the question, our officer here, and he said he could not answer it, would present it to you.
And you posed the question to who? Okay, gotcha, the chair, okay?
Yes.
And he said he could not answer it.
Could not answer that as a question for the judge. And he stepped out. I said, I'm just curious about making sure that our information is accurate. Trying to remember verbatim the responses. But generally it was just I apologize, I did not try to log that in my memory. I don't remember any particular responses as much as that might be good to clarify, would be good to know. And the conversation moved on, I believe, to traffic cameras. So,
to what?
That was the extent of the conversation. I'm sorry, I can't be more specific.
Your memory is fine, and
bring
so
out
did anybody
all the jurors.
Were there responses, or did they greet you with silence? Did you receive responses to the question?
The only responses I can recall to any extent was a general assent that clarification would be good to have.
Okay, and how was that general consent that clarification would be good to have conveyed to you? Was it a physical gesture? Was it a verbal?
Verbal responses to the extent of something to the effect of, oh yeah, that would be pretty good.
Okay. And do you know how many would have shared that? If you can approximate.
Maybe 3 or 4 people at most.
Okay. And those are my questions for you, but again, as procedure, I'm going to turn to the attorneys and see if they have additional questions.
So you just sort of in passing mentioned that the conversation moved on to traffic cameras.
Yes.
Tell us about that.
Was it like, could you describe the nature of what that conversation was?
Trying to remember because it was going between considering my question, sipping my coffee, and generally paying attention to traffic. So I apologize if this is not totally specific. We're trying very hard to not discuss the case in any capacity, and so we're finding other topics of conversation. People were discussing times that we've been clocked by traffic cameras.
Okay, so
that type of thing.
Sure. So it wasn't in relation to is there traffic camera evidence in going to be shown in this case? Okay.
No.
Okay. Thank you. I don't have anything further.
Okay. Mr. Rogers and Mr. Teague?
Yeah, we're good.
We're all good.
Okay, no additional question. Okay, and then juror number 33. It was mentioned to me that you had an extra notebook. Are you reporting any notes from the trial in that extra notebook?
The extra notebook was the initial notebook I brought in. I was unsure if notebooks would be provided to us. I left it here with the other one. I believe it just simply says jury notes and the date. And when I heard that we were not allowed to take other notes, the notebook was placed down on my feet and has not moved from that position.
Okay, wonderful. Thank you. And so again, let me, because I changed the topic, I'm going to turn to the attorneys and make sure they don't have any additional questions.
None from the Commonwealth.
Okay, thank you, juror number 33. And again, you were not in trouble, but we just have to make sure everything is perfect. And circuit court. That you can retire back to the jury room. Thank you very much.
Thank you, ma'am.
You think he's going to make it all the way to the end of the trial? We've had him in twice.
Anything additional before I take a recess to research and consider the issue? The mistrial motion made based upon juror number 33 having conversations with the other jurors.
My position remains the same. Nothing further.
Our position remains the same, and just want to note that the juror seems to not remember, according to him, not remember exact conversations that went on regarding the issue.
So again, I'm going to retire for deliberations. Just for human planning purposes, it'll probably be at least 15 minutes. So if people need to use the restroom or go to the car or something, please feel free to do so. I'll be honest, I'm inclined to deny the motion, even though both parties have made it. As the question for clarification, did you understand that? And the responses, I think will be harmless, but let me research it and consider it in detail. And I'll be back in, let me see, it's 9:54. So let's see, try to check in at 10:15. And then Madam Mayor will make sure jurors have, extra snacks and whatever they need. Because they've been in that room a good hour and 15 minutes by that point. Okay, I will be in recess. Thank you.
All right, she goes in recess, and now we have to fast forward a little bit. I have to laugh when she says, I'm going to research this because I don't know. Clearly, she doesn't know what happens here in this situation. But she's like, but honestly, I'm going to deny it in spite of both of you asking for it. I don't even think she's going to send the 2 jurors home. I don't think we're going to burn our alternates on day 2. Let's see what happens here. She's going to be coming back here in just a moment, and we're gonna find out. Oh man, here she's back. She's back.
Okay, all right. We are ready to resume the case of Commonwealth versus Parker. All parties are present in the courtroom, minus the jury, and there was a mistrial motion made. Of course, we had an opportunity to consider it and research it. Anything else parties want to say before the court announces a ruling?
Nothing from the Commonwealth.
Just Just for purposes of the record, I just want to clarify the motion as it relates to juror number 38. She submitted a series of 3 questions, which, again, we're arguing that helped, I believe, would aid the Commonwealth in planning out the rest of their case directly in response to her questions.
Thank you. In response to the mistrial motion made regarding juror number 38's question, the court will deny that on the legal principle that jurors in this matter are actually the triers of fact. And under law, they can ask questions of the witnesses. Now, our courts aren't set up to do that. We don't encourage it. We don't normally do that.
It's legal, but they can't.
It is not prohibited. All the evidence has not been presented in this case, and both sides can adjust accordingly based on those questions. But again, jurors are the trier of fact in this case, and they do have the ability to ask questions and can actually question witnesses. So that's
you just don't tell them that.
Regarding the motion to mistrial based upon juror number 33, asking questions of other jurors, which means discussions prior to the case being submitted to them for deliberation. The defense has moved for a mistrial. The Commonwealth has joined. The court is going to deny the motion for a mistrial, and the case will proceed. The court's rationale is as follows. The determination of whether a mistrial is warranted depends on whether the juror misconduct probably resulted in prejudice to the moving party. The burden of establishing this probability of prejudice lies with the party seeking the mistrial. The standard is abuse of discretion, and to succeed on a motion for mistrial, the moving party must demonstrate a manifest probability that the misconduct was prejudicial. The allegations of juror misconduct arise, or if, the allegations of juror misconduct arise, the trial court may be required to investigate the matter to determine whether the prejudice occurred. In this case, the defense, which is the moving party, has not established a manifest probability of prejudice. The court did investigate the juror misconduct. Again, the Virginia courts have delineated between misconduct inside the jury room and outside of the jury room. In this case, this would have been not outside, such as unauthorized communications with third parties or introduction of extraneous evidence, but it was misconduct confined to inside the jury room, specifically premature discussions among jurors. And case law has indicated that that is less likely to result in a mistrial unless it demonstrably affects the fairness of the trial. And in this instance, juror number 33 had questions about procedure to other jurors, not questions of fact. And I also want to make that distinction here. In addition, Virginia statute does provide a mechanism for addressing juror misconduct, and that is 19.2-262.01. So in summary, the misconduct here was not prejudicial, or is not prejudicial as found by the court, a legal decision, and a curative instruction can be given, and I will again bring them out and tell them that they are not to discuss the case, ask questions of each other about the case until it is submitted to them for deliberation. The case law that the court is relying on is Robertson versus Metropolitan Washington Airport Authority, Reiner versus Commonwealth, Caterpillar Tractor Company versus Holvey, and Bidet versus Commonwealth, in addition to the statute cited. All right, so with that being said, motion is denied, and we're ready to move forward. Can we bring the jurors out?
Judge, I understand that the defense has an objection to the authentication of the video that the court has already considered, and that objection is going to require me to lay a foundation by showing her the video and asking her to authenticate it.
Okay, so we want to do that outside of the presence of the juror.
I think so, and voir dire her both sides.
Mr. Rogers.
That is correct, Your Honor. Instead of bringing them out and then having to exclude them again so we could lay the foundation and authenticate the video, I think it's for judicial economy, we should just go ahead and bring her out, voir dire her, authenticate the video, and then if the court believes that the authentication is proper, go ahead and present the evidence to the jury. I do have another concern, and that is at the beginning of the trial, the court ordered that all witnesses be sequestered back in the witness rooms. I think there's at least 3 rooms, and I think there's multiple witnesses in each room, so that they
we sequestered them together.
The case may have heard about the evidence that has been presented in the case and maybe discussing that. And so I'm concerned that the court's ruling on sequestering the witnesses may have been violated and is being violated.
Okay. And again, I believe there are over 20 witnesses in this case, and we don't have the physical space to give them their own separate rooms. But of course, they are sequestered, and it's on the attorneys to identify them and to instruct their subpoena witnesses as to the rules. Do you have a basis for believing that they may have discussed the case?
No, I'm just believing that's a probability, of course.
Probability just because they're sitting in the same room.
And they're talking, but of course I'm not in there. I don't know what they're speaking about.
How do you know?
Without more specific information, that the court is going to deny your motion, but feel free to voir dire them regarding that when they take the stand. Okay. And Campbell's witness that we're going to pre-clear the testimony for evidence.
Yes, Your Honor. Nina Farish, Dr. Farish.
Okay. Bring out Nina Farish, please.
While the witness comes out, the jury is not here. We're now doing voir dire. She's going to be shown a video that is an interview, a Zoom recording of a conversation she had, an interview she had with the defendant over Zoom, asking about this event and different things that happened. Defense says you have to do this so she can authenticate it in terms of judicial, what do you call it? The timeliness. Let me tell you a word, sir. Stipulate.
Do you swear or affirm the testimony you're about to give
Stipulate.
is the truth, and nothing but the truth?
Judicial economy.
There's a stair, and the chair and microphone are adjustable.
Are you really trying to pretend that this was not your client?
Outside of the questions of the jury, any objections and evidentiary issues, and upon the ruling, we might bring the jurors out, and then redo it. So I just want to explain to you procedurally what's happening right now. If the attorneys have any questions, we'll start with the combo. Yes, Mr. Roberts?
Before the video is played, I would like to voir dire her during the video prior to her actually viewing it.
Okay, and I don't know what order Mr. Jenkins is going in, so do you want to start with the questions, Mr. Roberts?
Judge, may I propose that I lay an authentication foundation, not play the video, let the defense counsel voir dire as appropriate, and then the court will rule whether she can watch the video to authenticate it.
Okay. Yes, please proceed.
This is nuts.
Good morning. Could you please tell us your name and how you're employed?
Nina Farish, Human Resources Director with Newport News Public Schools.
Were you employed in that same capacity in January of 2023?
Yes.
And as part of your official duties as the HR director, were you required to conduct an internal investigation into the shooting at Rich Neck Elementary School that occurred on January 6, 2023?
Yes.
As part of your investigation, did you have occasion to interview numerous people?
Yes.
And technically, how did you conduct the interviews?
The majority of them I did via Zoom.
Okay.
Recorded.
And did you conduct an interview with someone named Dr. Ebony Parker?
Yes.
And what was, prior to January 6, 2023, what was Dr. Parker's title with Newport News Public Schools?
Assistant principal.
Okay. And do you see Dr. Parker in the room right now?
Yes.
Could you please just point her out for the judge?
Okay.
I'd ask the court to recognize she's indicated the defendant.
So noted.
You've indicated I'll ask it again because I'm not sure what your answer was, but did you do an interview with Dr. Ebony Parker?
Yes.
All right. And was that was that interview conducted in person on Zoom or some other way?
Via Zoom.
Okay. If you were shown that video or clips from that video, do you believe you would be able to recognize it as the one you created?
Yes.
Okay, thank you. For now, I don't have any other questions for you, but defense counsel, I think, does.
Good morning, ma'am. How are you?
This should be good.
Great. So, regarding any video that was produced, did you keep, or were you the sole custodian of that Zoom video?
Yes.
Okay, and where was that video maintained?
On my computer.
Okay. Did anybody else have access to your computer, or was it just you?
Just me.
Okay. Did you provide a copy of the video to anyone?
Yes, when asked by the attorneys.
When you say the attorneys, what attorneys?
The ones that represented the school district.
Okay. Did you provide a copy of that video to Mr. Jenkins, the Commonwealth?
No, I'm trying to remember the name of the law firm because, as I recall,
so the civil attorneys?
Mr. Jenkins was not the original attorneys.
The civil attorneys?
Correct.
Okay. So have you gotten a chance to review the video that's in the possession of the Commonwealth?
Yes.
When did you review that video?
I reviewed the copy that I still have, and I reviewed it to refresh my memory.
Okay. I want to make sure that you understand my question.
Okay.
The copy of the video that the Commonwealth has, have you reviewed that?
I don't know what they
I'm not sure how to answer that question because if I didn't give it to the Commonwealth, I don't know which video then you'll reference.
That's right. So you did not personally give the Commonwealth attorney a copy of the video, and you're not sure that the video that the Commonwealth has is an accurate copy. Is that correct?
That's correct.
Okay. So the video that the Commonwealth has, you don't know if it's actually been altered. Is that correct?
That's correct.
Okay. So you don't know how many hands that video has gone through before it actually came into the possession of the Commonwealth. Is that correct?
Correct.
Okay. So you really can't verify the accuracy of the Commonwealth's video.
Correct.
Okay.
Without seeing it, and then she can because she's compared it to her original.
Can I have a motion on it?
Yes, sir.
That was your argument, sir? Oh my goodness. Trying to trick her into saying I can't authenticate the Commonwealth's video is not going to work.
Okay, and this recorded video, is it stored in your office, or is it stored in the cloud someplace, or is it stored on Zoom's Zoom app, or how is it actually? How is it preserved?
It's on my laptop.
Okay, so you actually have a copy of it on your laptop.
Yes.
I would call it the original because I've never, except when subpoenaed, made a copy.
Okay, and again, you provided that to the civil attorneys, but not to the Commonwealth.
Correct.
Thank you.
I'll tell you what, I'm going to let Mr. Chief step in.
Good morning, Ms. Ferris. Regarding the video that you're saying that you recorded, did you record it or did the Zoom platform record it?
Well, I pressed record, but it was the Zoom platform that's recording.
Okay, so you did not actually record it with your own device or anything like that?
No.
And so the actual video was something that you downloaded from Zoom?
No.
Or was provided to you later?
No.
Via Zoom, correct?
No, it records on the laptop. Don't say yes, ma'am.
Repeat that question.
You said I believe your testimony is that Zoom recorded it. You pressed record on the Zoom platform.
Correct.
And Zoom recorded it.
Yes.
On the laptop.
And then you were able to, I'm assuming,
locally.
download it in some way, or how did you get it onto your computer?
I have the Zoom app, so then I just reopen the recording, and it can play for me.
Okay. Thank you.
Done a lot of Zoom recordings of meetings.
And one moment.
They're recorded locally.
Before we,
Just arguments at this particular time.
okay, and your arguments are towards the video?
Your Honor, she testified that she cannot verify the accuracy of the video that the Commonwealth has. She hasn't viewed it. She's testified that she cannot verify that the whatever video the Commonwealth has not been altered in some way. There's all sorts of ways to manipulate a video. It could have been run through artificial intelligence and altered. She testified that she can't. She's not in a position to be able to verify that.
As an officer of the court.
Do I have permission to play the video?
Yes. And Mr. Rogers, did you want to say something?
Your Honor, what I don't want to happen is that she's already testified that she cannot verify a video that's in possession of the Commonwealth is accurate. So
because she hasn't
what
seen
I
it
don't want to happen
yet.
is for her to see the video and just sign off on it without actually having it examined ahead of time to determine its accuracy.
Judge, if I may.
You may.
The two things I need to say about this. One, the video I'm going to show consists of 3 clips that I intend to admit from a larger video that defense counsel received in discovery back in November. So it has been altered in the sense that I'm only showing the parts that I seek to admit into evidence. Also, it has been altered to mute the name of JT. But if we want to use the original, I have no objection to that. It's just longer and contains what I believe to be pretty irrelevant, but I wouldn't object to it. I'm happy to show it to her now, and we will see whether she recognizes it as being clips of the interview that she conducted.
All right, and the 3 clips, are you able to give me a duration of each clip?
Because they are in one file.
If you can't, that's fine. I just didn't know if you can.
The total duration of the 3 is. Let me make sure before I say.
I don't think that was a good faith argument. He's saying it could have, but yeah, but
16 minutes and 36 seconds is the total duration.
Okay, thank you, Mr. Jenkins. Yes, Mr. Rogers?
Commonwealth has already admitted that the video has been altered. So with that admission, she can't authenticate it. There's been, Commonwealth would say minor alterations, but Your Honor, I'm not comfortable with just presenting clips. She needs to authenticate the whole video, and if part of it comes in, I think all of it needs to come in.
Okay.
seriously? I realize you don't want this in.
Do you have any authority for that position, Mr. Rogers? Because I'm unaware of the authority that if she is able to say that this is an accurate, fair and accurate representation of the interview she conducted, what authority indicates that it can't be redacted to the relevant parts and that we cannot mute sensitive information such as the names of minors involved? What authority do you have for that that makes it inadmissible?
No, I don't have any authority regarding the muting or the name of a minor, but I'll just cite Baez versus Commonwealth. And I've got a copy of it before.
Okay. And regarding clips, 3 clips versus the entire video.
It doesn't directly address that. It doesn't address that.
Okay, but the other thing you're saying If they get parts, I want the whole one. How do you wish to do that?
Your Honor, I'm going to object to just a part of it because of the importance of context. If some of it comes in, I just believe that the jury's entitled to it at that time.
And Commonwealth, they're not objecting to that. So what I'm asking you is, how do you want that? And well, let me back up. Mr. Jenkins, how long is the entire interview?
Oh, I will have to look at that.
That's when I asked Mr. Rogers, are you asking him to play the entire interview?
Yes, ma'am, essentially.
Okay, that's what I want to know. How long is the interview?
We're not set up to watch videos in this court. We have a little TV that we get at like a 5-degree angle on. In this video, allegedly the defendant makes comments that would basically sink her case.
The whole video is 28 minutes and 58 seconds, I show. Let's see if that's right.
Okay, that's nice. Okay, all right.
Judge says roll tape.
Play the whole video for the jury should it meet the other authentication things. Anything else, Mr. Rogers?
That's it.
Okay. So, Mr. Jenkins, what are you prepared to play now for the witness?
Well, I can play the whole video if that's what it's going to take to authenticate it. If defense counsel would agree to let me show her a freeze frame and verify, we can do it that way. But.
Ms. Roberts?
So I'm going to ask that she be shown the entire video, but then when it comes down to the presentation of the evidence, then I would suggest that the Commonwealth could show clips at that point. But I want the jury to have the whole video. I want the whole video reading the evidence.
Oh my goodness.
I think I understand that the defense is wanting to admit the entire video into evidence on a disc so that the jury could see the whole unedited, unredacted video and only play for the jury the clips, the 3 clips with the redactions in place. And if that is what the defense is suggesting, I do agree to do that. I think that's fine.
If the court feels that it has been properly authenticated.
Okay, all right. So we agree to proceed in that manner. Except she doesn't need to watch the entire thing. Ms. Farrah, she's going to show you portions of the video and answer you questions about it. But in terms of the entire video, if at any point you say that that's not accurate, please let us know.
Defense actually did ask for her to be shown the entire.
Yes, Mr. Dick.
Just before we start, I would note that Mr. Commonwealth has indicated that all of the 3 clips have been melded into one file, so they've been joined together, which I think obviously would mean that it jumps from clip to clip without the context in between. So I do believe that there may be some issues with playing just those 3 clips, especially if they're in one melded video that's combined into one file. I don't think that would be. I don't think that would be fair to Dr. Parker because it would leave out. I'm assuming that he's jumping. Had it not having seen this video, the splice one, it jumps. He's saying that he's joined 3 clips together into one file that plays continuously.
Okay, well, let me hear from Mr. Jenkins.
Judge, the 3 clips that I'm playing are melded together, so to speak, as defense counsel says. But I am happy to tell the jury, and I'm sure Your Honor may as well, that I am showing clips and that they will have in evidence the full unedited, unredacted video. And the jury can know that up front, and I see no problem with that.
Okay, and to the 3 clips, because they're spliced. In between the splicing, is it obvious on the video that this is a splice and we're going to jump forward in time and hear another portion and then we're going to jump forward in time?
It makes a small jitter or jump, it is all, but it doesn't, fade to black and come back up.
Okay, so there's some kind of visual signal that something is happening.
Admittedly, you have to be kind of watching closely because it just jitters, the people move oddly, and that's when the new clip starts.
Understood. Okay, so what is defense motion? Because Mr. Rogers said it's okay to play it, but as long as they get the entire video for deliberations, Mr. Teague is saying play the entire video. We're talking about 12 extra minutes.
We've been talking for 20.
Yes, sir. I think that that's an alteration that goes beyond using people's names and clicking, making slices that are obvious to the jury. I just don't think that should be played to the jury.
Given that, Judge, here, I am offering that into evidence. That is what I'm offering, the clips. And the counsel is free to offer whatever they'd like. They have a copy of the video.
No, we don't agree to admitting a spliced, altered video into evidence. We just don't.
Okay, give me the authority that indicates that that's not admissible. I'm not aware of it.
I can tell you what it is. The rule of completeness. If you argue rule of completeness, you can say this is taken out of context. You need to see the surrounding comments to get the full understanding of what the recorded or the played segment means or what they're talking about. Under rule of completeness, defense can ask the whole thing be played. They can. They don't want it played. It's bad for their client.
Supreme Court of Virginia, December 19th of 2024. And so I will begin, but the rule begins at, you'll see designated paragraph 1819. That's probably like 6 pages back. It says, beginning of that paragraph, it says, photograph or video which is verified by the testimony of the witness as fairly representing what the witness has observed is admissible in evidence, and it need not be proved by the individual who made it. And then I'm just going to go on down. It says a silent witness or a witness that speaks for itself. Video or photograph evidence is admissible when given an adequate foundation ensuring the accuracy of the process producing it. Obviously, this splice video is not something that she's going to be able to verify the accuracy. And so, going down to paragraph 2223, the second sentence, focusing the authentication quality on one truth known as too narrow to bear on the genuineness of the video as a whole. And then going down to paragraph 24, it says, for witness to affirm that a video is accurate. So in terms of video,
stop touching stuff.
Every moment, rather than seeking for a witness to affirm the video accurately represents what transpired based on the witness's observation. So, Commonwealth has submitted this video in its form as it's been offered. Obviously, the Commonwealth is going to be presenting the video that points more to Dr. Parker's guilt than innocence. So, in this form, it's highly prejudicial to Dr. Parker, and we don't believe that just social care should be presented. As the Commonwealth has a certain prepared.
They're trying to go back and relitigate this.
Ms. Ferris had not seen the clips in the form, and so she can't verify the process of how even these clips were produced.
Judge, would you like me to respond?
No, sir.
Pause it between the cuts. Play the whole clip for her.
The court is going to allow the Commonwealth to play the 16-minute clips of what the relevant portions are to the Commonwealth in their perspective. Again, the evidentiary rules are about reliability. Is the thing what it purports to be as proclaimed by the proponent? Are the legal principles involved? And is it a fair and accurate representation? Once those are satisfied, it comes in. I note the defense's exception. Mr. Rogers also brought in the word prejudicial. I don't think he's laid an adequate basis for why this is prejudicial. So you may proceed with your attempt to authenticate this, and then we can get moving with the jury trial.
Okay, Your Honor, given the court's ruling, the video that I'm about to play is the video that the Commonwealth would seek to admit into evidence that has the 3 different clips.
Yes, sir.
Your Honor, before we go, so there was discussion about if the video was admitted, presenting the complete unredacted copy to the jury. Was that still?
Is that still a defense request? And the Commonwealth is in agreement with that?
Yes.
We're just talking about the parts that you all were not able to reach an agreement.
Okay.
Okay. All right. Yes, sir. You may proceed.
Thank you, Judge.
Finally.
Okay. So, Dr. Parker, thank you so much for joining me today.
Good audio.
I'm here to first ask if you are giving permission for me to record this session to discuss the incident that occurred in Rich Neck on Friday. Yes. Okay. So as part.
If I may, Judge, ask the witness, does what I've shown so far appear to be the interview that we've talked about?
Yes.
Okay. Judge, I can keep playing a little more, or I believe she's laid a foundation that this is the interview.
Mr. Rogers?
She's only seen my client's face. She's verified that I was just going to ask it for purposes of identification. There's no way she can verify that what's on this 16-minute clip is accurate. She has to see it.
Ms. Jennings, if you just jump to 2 other sections, if you're able to, and play about 10 seconds and ask the same questions.
Okay, I can.
Video audio is better than live court. It is.
Sorry. I'm seeing at the bottom of the screen a date and time stamp, and those are military hours. So those will move as you move your cursor?
Yes,
okay.
Your Honor. So I can make a record of those.
Okay, and I didn't know if that's on the video or if you have another cursor mark on your laptop that's showing the different timestamps.
So I have on the laptop, it is in absolute time, meaning 0 to the end of the video. But what I believe is on here is in the date and time it was recorded.
Okay, understood. Okay, yes, please. Okay, proceed. Thank you.
So I'll resume playing the video from 15:38:28.
And he left. But those are the only 2. Okay. So, help me understand.
And Dr. Ferris, does this still seem to be your interview with Dr. Parker?
Yes.
Okay.
On January 9th at 3:38.
Jump forward a bit more. I've now jumped ahead to 15:47:26, and I'll play from there.
I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday. Okay, all right. So just to be clear.
And Dr. Farish, same question. Does this still appear to be portions of your interview with Dr. Parker?
Yes.
All right. Judge, with that, I think we've laid a sufficient foundation for authentication purposes for this video.
Anything additional from the defense?
No, just to try to stress the whole point of authentication is to verify accuracy. Your Honor, it's going to be the first time that she's going to see these clips as the Commonwealth has prepared them. We don't know what type of manipulation has occurred from. She didn't give this record to the Commonwealth. She gave it to other attorneys. We don't know what kind of manipulation occurred in the
That's something to argue pre-trial.
Any IT professionals, any other person between the chain from Ferris, the other attorneys, and now the Commonwealth. Just showing her those very few seconds that she's not verifying the accuracy. She's verifying that essentially that's her talking to Dr. Parker. That's it. She's not verifying the accuracy of the contents of that video.
Yes, sir. Okay, so again, the defense will continue to note their objection for the record. The court, again, is going to allow this video to be played to the jury for the rulings it's previously made. But again, the defense exception is noted.
Judge, may I please request to make a quick record related to
I'll let you make a record.
Thank you.
But the court is also going to give a cautionary instruction to the witness. At any point when this is played, if you see something that is not accurate, please immediately say so we can address the matter.
Yes, ma'am.
All right, thank you. Yes, Mr. Jenkins.
I just want to quickly, in response to, for the purposes of the record, Rule 2901, requirement of authentication. The requirement of authentication is satisfied by evidence sufficient to support a finding that the thing in question is what the proponent claims. So it is not about accuracy. It's about is what it claims. The arguments counsel has made about chain of custody and accuracy of the video, those go to weight, and he is free to make those arguments to the jury. They don't go to admissibility. Thank you for allowing me to do that, Judge. I think we're ready for the jury.
All right. Sheriff, you kindly bring the jury out, and you ask all parties to stand while the jury comes out. If you're able.
Your Honor, I'm going to step out and let them.
Okay, well, step out, Mr. Rush. Yes, sir. We'll wait till you come back.
Thank you.
I'm sorry, everybody. Get your knees in your back stretch. Yeah, it's a good stretch break. Let's stretch. There we go.
Apparently he gets his knees in his back. He sees a physical therapist on the breaks, I guess. Oh my goodness. Hold please while I preview a song that might have just dropped off my record label. Hang on. This is for my ears only right now. I'll tell you if it's good. This song's terrible. Okay, we're working on a song. The one I made is not it. It is not good. I'll keep working.
And we will bring the jury out. Thank you, Sheriff. Again, okay, let's practice again. Let's all think.
It's talking about blue shoes and trains and weird stuff. AI hallucinated on that one. Like, a lot of weed went into that song. And maybe some acid. But, here comes the jury. Now we get to play this video. That is the largest pattern of that, what is it called, houndstooth pattern I've ever seen on a jacket. It's massive.
Jurors in the box, please.
Thank you so much. Everyone can take their seats, please. Do you mind having your head count? All 14 jurors are in the box. Happy Wednesday to everyone. Thank you for the time. This morning. I know you've been there for about 2 hours. We were working on some motions to hopefully keep a swift pace through the day. As usual, we'll try to break around 1. and try to include around 5 for evidence for the day. And if you need any breaks, let me know. Now, I haven't asked the parties, the juror box as a whole, but we have that cautionary instruction not to research this case outside of what's presented to you in the courtroom, not to discuss it with others, and if somebody approaches you, to inform the court. Does anyone wish to report any potential misconduct or issues? Okay, and there is nothing being said, and for the record purposes, parties are shaking their head in the negative. And again, I'll give another cautionary instruction. Again, amongst yourselves, please do not discuss the case or ask questions until this case is given to you for deliberation. That's a specific legal moment and legal procedure. So you can talk about the weather, talk about family, but just don't talk about the
traffic cameras
amongst yourselves until the case is given to you for deliberations in that moment. Okay, with that being said, we are going to proceed with evidence today. The witness has already been sworn in, and the Commonwealth will start their direct examination. Mr. Jenkins.
Thank you, Your Honor. Good morning again.
Good morning.
Would you please tell us your name and how you're employed?
Nina Farish, Human Resources Director for Newport News Public Schools.
And Dr. Farish, how long have you been in that role?
For 4 going on 5 years.
And so were you in that role on January 6, 2023, and in the month of January 2023?
Yes.
Do you know someone named Dr. Ebony Parker?
Yes.
And was she employed by the school system?
Yes.
How so?
As an assistant principal.
Okay. And is she in the courtroom right now?
Yes.
Could you please point her out?
Yes.
And Judge, I'd ask the record reflect that she's identified the defendant.
So noted.
After, did you become aware of an incident occurring at Ridge Neck Elementary on January 6, 2023?
Yes.
And after that incident, were you called upon to investigate it?
Yes.
Generally, what was the nature of the incident you were told to investigate?
A student shooting at Ridge Neck Elementary School.
Understood. As part of your investigation, did you conduct interviews with many people?
Yes.
Did you conduct an interview with Dr. Ebony Parker?
Yes.
And technically, how was the interview done?
Via Zoom, recorded.
Okay. If I were to show you different clips that have been edited of that interview, would you be able to recognize those clips as being the interview that you did?
Yes.
Okay. Judge, with the court's permission, I'll publish this to the jury and indicate as well that this is 3 clips from a larger video that we will enter into evidence as well, and that the audio on this has been muted wherever a child's name was spoken. May I publish to the jury?
You may, and for the jury, the defense has objected, and the court has allowed that the video will be played. I don't think it requires dimming, but do either of the attorneys want the courtroom to be dimmed?
Not
if we could get some mood lighting, that would be great, Judge.
Okay. So Dr. Parker, thank you so much for joining me today. I am here to first ask if you are giving permission for me to record this session to discuss the incident that occurred at Ridge Neck on Friday.
Yes.
Okay. So as part of our internal investigation, I have some questions for you. I do ask that you please answer the questions honestly. I also ask that you please keep our investigative conversation confidential so that to maintain the integrity of the investigation, because I do have several people I need to speak with. Okay? Okay. So, Dr. Parker, let's start with Friday. Were you given any knowledge prior to the actual shooting that the student had a weapon?
I was told that
the students reported that the student had a weapon in his backpack.
Oh my goodness.
So,
Done.
okay. So, Ms. Kovac, we're allowed to use names, right?
Yes, ma'am, please.
Okay, so Ms. Kovac was the one who informed me of this. And she said that she had already asked the student, is there something in your backpack? And he said no, but she had brought it to me. The class was about to go outside to recess, so I said, well, when they go outside to recess, we can check his backpack. I was in the midst of the winter growth assessment, printing off tickets and such, so I didn't go into the classroom with her. When she came back, she says, there's nothing, I didn't see anything in his backpack. And I said, okay. And she said, but, what about in his pocket? And I said, well, I don't know. Are they going out to recess? She said, yes. She was also my person that was helping me with testing. So, I don't know if she went outside or not, but there was a comment that said, well, we watched him closely. Assuming she meant herself and the teacher. And I said, okay. And then I went on with testing.
So was all of that conversation from Ms. Kovac all at the same time, or did she come back to you with the comment about we watching him?
She came back.
Okay. So, do you remember approximately what time it was when she reported to you, the students reported that he had a weapon?
They were going outside for recess at 12:20, so it was right before that. So I don't know how far between them, but I know from the time that she said it to the time that they went outside for recess, it wasn't very long.
Okay. Did you report this to Ms. Foster?
I did not. She was in a meeting with a military counselor that we were supposed to be getting, and I was supposed to be going into that meeting at 1. The meeting was at 1, and I didn't make it into that meeting. But because I was in the midst of testing, I don't leave my office when we're in testing to maintain, the testing tickets and the security of that. And so I had not spoken with Ms. Foster.
Okay. So can you tell me, did anyone else come to you before the shooting to tell you that the student had a weapon?
So, after we checked his backpack and there was nothing there.
And you say we?
Well, I say we because I said check it. So, but Ms. Kovac went in to check it.
Okay.
Yes.
Okay.
But I said we because she came to me to ask, should we check his backpack? Do we check his backpack? Mr. Rawls, after that situation was settled, came back into my office and he said, hey, did you hear what they said about? I said, yeah, I heard. I said, but we checked his backpack. And again, I'm still using we, but it was Miss Kovac. I said, his backpack was checked. We didn't see anything. And he says, oh, okay. Did you check the person? And I said, ooh, no, we didn't. And I remember looking at the clock and it was 1:40. And this particular student is on a modified schedule. So I said, his mom is due to come here soon. So when his mom comes, we need to inform her of what was said, what we did, and then she can, we'll let her go through the rest of his things and check it. He nodded his head and he left. But those were the only two.
Okay. So help me understand, What is your understanding of what should have taken place from the first notification that you received about the student from Ms. Kovac possibly having a weapon?
What we did in previous times before, we had 2 other students who also reported to have a weapon, and we, asked the student, do you have something that say, no, we do have someone else come in with us. It took up in a backpack, but we never searched a student. So because we didn't, Ms. Clark didn't see anything in the backpack, then we didn't do anything from there. His mother does come in every day, and we have a conversation every day. So I was waiting for Mom to come in.
So in the past protocols of what you've done, correct me if I'm wrong, you've brought the student into your office, and you, along with who else?
So the first time it was Mr. Rawls, and then the second time it was an incident of a parent had already called the police because the report was given to her from her son, so she had already called the police. So the second time it was the police was at the school.
Okay, all right. Had Mrs. Warner on that Friday come to you and express concern about the student, about the student's behavior, or did she express that she thought the student had a weapon?
No. So Ms. Warner never said that she thought that the student had a weapon, and she never said to me directly that it was reported to her that the student had a weapon. So I was about to get the PM session of the testing started, and she came into my office and she said, is being extremely defiant today. And she says, if he hits me, I don't know what I'm going to do. So I acknowledged what she said, and I said, oh, okay, and then she left. So I told Ms. Kovac, because they were going to go back as the kids, I said, if she feels that he's being, uncontrollable, she can't control him, tell her to call his mother so she can come and pick him up early, is what I said. But no, Ms. Warner never came to me and said anything about her fearing that the student had a weapon or that she felt unsafe. She didn't. She didn't say that to me.
Okay, all right, take your time. Had Ms. Warner, prior to Friday, ever expressed to you that she had concerns or felt unsafe with this particular student?
No, so has been on a modified schedule since the beginning of the year. His acting out was he's extremely defiant, and he does the exact opposite of what he's asked to do. And it was making it difficult for her to do instruction in the classroom. So we sat down and we made a modified schedule. We had things in place. So somebody was getting the bus. He was going to Miss McBurnett's room to do a social story. He was then transitioned to Miss Kovac for a 15-20 minute small group session before he spent time in his classroom. And Wednesday, he had asked to come to the office, and he said no. Ms. Warner said no, he couldn't come to the office. And he took her phone and threw it down. So it cracked her screen. Ms. Foster and myself, I sat in the meeting, but Ms. Foster had, facilitated a meeting that afternoon with we told, hey, the damage that it is to the teacher's phone, we'll let you know. She understood that she was prepared to pay for it and everything. So, in hindsight, that evening, I spoke with Miss Foster, and she said, I really think I'm going to call Mom back because he should have gotten a consequence for what he did. And I said, well, yeah, but, I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday.
Okay, all right. So just to be clear, at any point in time prior to Friday, did Ms. Warner ever report to you that she had concerns about the student or about her safety with that student?
No. The concerns were around the student and his behavior. Never has she said, I feel unsafe.
So when she made the statement to you, if he hits me, I don't know what I'm going to do. Can you tell me where that came from?
So that Wednesday, where I feel it came from was that Wednesday when he took her phone and threw it down, he went to a buddy classroom, which was Miss West. And what Miss West reported to Miss Newton was that he was pinching at her, but I did not get I didn't get the full report of that incident. So when she said that, me knowing that was what was reported Wednesday, that's where I think that came from.
Okay. Was there ever a comment made to the teacher that she was overreacting to the student or his behavior?
No.
Okay. Prior to Friday, had anyone, Ms. Warner or anyone, reported to you their concerns about the student or about their safety or possible safety of others in the building because of that student? Okay. So, staff stating that administration knew, what is your response?
Could we pause the video?
Yes, you can pause it. Yes, sir.
Can I have just a moment to talk with the council, and then I think I have an objection.
A brief moment.
I think we missed 2 objections during that previous long 2-hour argument about this case. So I'm going to go ahead and add those now. That'll put us up to 50 for the counter. Then we'll add to it if there's another one here. Staff basically told Human Resources that...
Sir, there's a lot of, I would say, hearsay statements that are being propounded by the stairs, things that other people may have said. And so I understand the video is coming in, and it should come in regarding my client's statements. But any statements made by Ms. Ferris, I would submit to the court that I believe those are hearsay. Any statements that she is alleging was made or declared by another party, I would submit is hearsay. And I would ask the court to instruct the jury not to consider statements of Ms. Ferris or what somebody else may have said, but only consider my client's responses to those questions.
Judge, I would ask that we continue playing the video for now and make a decision about whether there needs to be some sort of curative instruction after that.
It's not the best.
So I will, again, continue to play the video, but I will grant defense's motion that will give a curative instruction instruction. So we'll prepare that when it's time for instructions. Whose testimony they can consider from this video and the hearsay. All right, you may proceed, Mr. James.
Play and then go sit down, please.
Judge, may I back up just a little bit to give context?
Yes, sir.
I'm going to start back at 15 hours, 50 minutes, and 0 seconds.
It's here the question, so staff.
Administration knew. What is your response to that?
I don't know because what I did and what we did in the moment with how to support with him is what I thought the teachers, Ms. Warner, was asking for. Like, just I can't get instruction done. He doesn't sit down in his space. He won't follow directions. Those were the things that Ms. Warner were reporting to me.
Okay. I want to go back real quick because I want to make sure I'm clear on something. Ms. Kovac, check the bag. What is Ms. Kovac's title?
She's our reading specialist.
So help me understand why Ms. Kovac why did you direct Ms. Kovac to check the bag?
So, in the midst of testing, I don't remove myself from the office. And when the conversation we had was, should we check his bag? And the reason why we waited till they went out to recess is because I couldn't leave to go and check the bag. So it was my director that said, Ms. Kovac, when they go out to recess, check his bag.
Okay.
So she waited.
Did you talk to your resource officer that day?
She was not there.
Okay.
The resource officer, the actual, I didn't call, no. I didn't call. And our security officer, Ms. Lee, she leaves every day at 2 o'clock.
She leaves at 2, so Ms. Lee was...
I'm sorry, not 2 o'clock, 12 o'clock. And she comes back after McIntosh's dismissal, for our dismissal. So she's with us in the morning from 9 to 12. I'm sorry.
Okay. Okay. All right.
There we go. Those were our clips.
Dr. Parrish, was what you just watched a fair and accurate depiction of some clips of a longer interview that you did with Dr. Parker?
Yes.
Judge, at this time I would seek to admit into evidence a USB thumb drive and an envelope labeled HR Interview Parker that contains the clips that have just been shown to the jury. I would move to enter that as Commonwealth's 2.
I so introduced over defense's previous objections.
Showed the jury first and then admitted it.
Be marked as Commonwealth 2.
And Judge, at some point I will need to take a moment to get the full and complete video saved to a drive, and at that time I will move the full video into evidence as well so that the jury will have access to it.
Yes, sir. Any additional questions for this witness from the Commonwealth?
Yes, Your Honor. Dr. Farish, do you serve as a custodian of records for the purpose of providing things pursuant to a subpoena?
Yes.
And you do that for the school district?
Yes, sir.
Okay. And I want to direct your attention to any publications that the district makes that are official. Is there a rights and responsibilities handbook?
Yes.
And is there one in particular that contains a student code of conduct and also is for the year that was applicable, the 2022-23 school year.
Yes,
Do you have that document with you today on the stand?
I do.
Would you mind pulling it out? And did you bring that with you today?
Yes.
Okay. I'd like to direct your attention to that document. And specifically, if you would look on page 28 of that document, let me know when you're there.
I'm there.
I'm going to just direct your attention to a paragraph that begins principals and school. Do you see that paragraph?
Yes.
I'd like to ask you to read just that paragraph into the record, please.
Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles.
Okay.
Yes, what's the objection?
Lack of foundation, Your Honor. Ms. Ferris is not the author of this document. She has not established that she has authored it or was otherwise familiar with it. She testifies that she responds to subpoenas and things of that nature, but she has not made that the proper foundation has not been made.
The court has already ruled on that. It is
we ruled on hearsay, but we didn't rule on foundation.
Okay. Well, she has testified that on hearsay, we had a ruling that this was a public record. She testified that she is the custodian of records and that what she's reading from is in fact an authentic record of the Newport News Public Schools. She brought it with her here today herself, and that it was in effect on the time in question.
That's foundation.
That's all the foundation that is needed for her to tell us the content of that document. It is admissible.
The court rules the proper foundation has been laid. If you would repeat your question of what you asked her to read.
Yes, Your Honor. So thank you, Dr. Ferris. This is page 28, a paragraph that begins, principals and school security officers. Could you read that paragraph, please?
Yes. Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles, when there is reasonable suspicion to do so. Students should understand that they have no expectation of privacy to their lockers, personal property, or vehicles allowed to park on school property. Consistent with applicable legal requirements, school division personnel may use search techniques such as metal detectors and use other lawful search techniques.
Thank you. I want to ask you now about a different document. Does the public school system require individual schools within the district to create a multi-hazard crisis and emergency management plan?
Yes.
And during the course of your work, if such a plan is subpoenaed in litigation, are you the custodian of records that would provide it?
Yes.
Do you have with you, or have you brought with you to court here today, the Richneck Elementary Multi-Hazard Crisis and Emergency Management Plan for the 2022-23 school year?
Yes.
And is what you have here today with you a fair and accurate copy of that plan?
Yes.
Okay. Please give me just a moment. I'd like to direct your attention to page 18.
Yeah, I'm going to request some idea on her foundation of knowledge regarding this particular document.
Okay.
If the voir dire is going to admissibility and it's going to be allowed, we will have to remove the jury from the room because admissibility is not a factor for them.
Yes, sir.
And what's the basis for this again?
I don't think the proper foundation has been laid regarding her familiarity with this document itself. Again, he says that she responds to subpoenas and produces it in response to subpoenas. That does not mean that she has familiarity with the document, knowledge of who created it, or anything of that nature.
So I'm not going to allow additional volunteer at this point. Mr. Jenkins, can you try to lay a better foundation?
Okay, Dr. Ferris, let's back up. Is the multi-hazard crisis plan for 2022-2023 required by law to be created by the schools?
That is my understanding.
Okay, and are the plans records of the schools?
Yes.
Official records?
Yes.
Okay. And is what you've brought here today an official record of the school that was in effect at Rich Neck on 2022-2023 school year?
Yes.
That's better.
Foundation has been established, you may proceed. Objection is overruled.
So I'll direct your attention to page 18. Do you see the heading that begins imminent warning signs?
Yes.
18? And also, I want you to just look over to page 19. Do you see the heading that says mitigation?
Yes.
I am going to ask you to read everything between those 2 points, stopping before the mitigation heading.
Okay.
And also, the court reporter is writing this down, so if you could read relatively slowly to make sure.
Your Honor, I'm sorry, I need to select someone.
Did you say objective?
I'll provide it, Judge.
He just wants a copy.
Thank you. All right, you may proceed.
Unlike early warning signs, imminent warning signs indicate that a student is very close to behaving in a way that is potentially dangerous to self and or to others. Imminent warning signs require an immediate response. No single warning sign can predict that a dangerous act will occur. Rather, imminent warning signs usually are presented as a sequence of overt, serious, hostile behaviors or threats directed at peers, staff, or other individuals. Usually, imminent warning signs are evident to more than one staff member, as well as to the child's family. Imminent warning signs may include serious physical fighting with peers or family members, severe destruction of property, severe rage for seemingly minor reasons, detailed threats of lethal violence, inappropriate possession and or use of firearms and other weapons, other self-injurious behaviors or threats of suicide. When warning signs indicate that danger is imminent, safety must always be the first and foremost consideration. Parents should be informed of the concerns immediately. School communities also have the responsibility to seek assistance from appropriate agencies, such as Child and Family Services and Community Mental Health. Immediate intervention by school authorities and law enforcement officers is needed when a child has presented a detailed plan, time, place, method to harm or kill others, particularly if the child has a history of aggression or has attempted to carry out threats in the past. Is carrying a weapon, particularly a firearm, or has threatened to use one, or exhibits other threatening behaviors.
Thank you, Dr. Parrish. I'm going to direct your attention to just one more section of that same document. We're just going to page 60. And on page 60, do you see the heading Weapons Threat?
Yes.
I'm just going to ask you to read only that section that falls under the heading Weapons Threat.
If a student or other person makes a threat with or about a weapon, gun, knife, or other weapon, evacuate the area, evaluate the perpetrator, isolate, consider lockdown, notify law enforcement, remain calm, get help, avoid heroics, do not threaten, keep a safe, non-intimidating distance, avoid abrupt, sporadic movements, look for an escape route.
Thank you, Dr. Ferris. That's all the questions that I have for you. Please answer any questions from Defense Counsel.
You may.
Still morning. Good morning again.
What a morning it's been.
All right, a lot to unpack. So just to go over again, you are the HR director for Newport News Public Schools, and you conducted an independent investigation of this whole incident. Is that correct?
That is correct.
Okay. And in your investigation of this whole incident, did you have access to the videos from school property or any other videos that...
Objection. This goes beyond the scope of the direct exam and, is also asking about the investigation and other things that I didn't go into.
Relevance.
It was elicited on direct. That's one of the first things that she testified to, is that was her responsibility to do a complete investigation of this incident.
Okay, and that was one part of your question, but there were other parts. So I was trying to figure out where the scope of objection lies.
So I'm asking her about how she conducted the investigation. I think it's a fair question, Your Honor.
And what part was your scope of objection towards?
The concern, Judge, is getting into the findings of the investigation, but as to did she conduct an investigation and what did she observe in the investigation, I wouldn't have an objection to that.
I hadn't gotten to the point where I was asking for a conclusion at all, Your Honor.
All right, okay. But if he's planning to get there, I think he's going to object.
Well, we'll see what happens as we go along.
All right, you may proceed.
Okay. So you did conduct a complete investigation of this from the beginning of the incident to the end. Is that correct?
Correct.
Okay. And as a part of your investigation, did you view the videos that may have been taken, produced on Newport News School System's surveillance cameras?
Yes.
Okay. Did you also look at videos that may have been produced by Newport News Police Department?
Not by the police department, no.
Okay. So could you describe how many different positions video cameras are placed at Rich Neck Elementary School?
You want me to describe? You're not asking me how many?
I'm asking you how many. How many different positions, sir? Is it?
I don't recall how many.
Okay, well, let me ask you a different question. Would you say that you could pretty much, through this video surveillance, monitor most of the activities that occurred at Rich Neck Elementary School?
Most, yes.
Okay. Were you able to see what things occurred in the hallways?
Yes.
Objection, Judge. We're getting into the content of things that he's not planning to show. He should be required to produce those videos if he's going to ask her about those videos.
Response?
I don't think I'm required to show anything. She's testifying. She's producing evidence. I don't have to cooperate that by video.
And what objection is this? What legal principle is invoked here?
Lack of foundation.
Your response?
He uses
Your Honor,
foundation.
she's testifying as to what she observed. So, she looked at videos. She's testifying as to what she observed on these videos. So I'm not asking to introduce these videos. I'm just asking her what she observed on these videos.
And are you going to ask her to describe what she observed on those videos?
She is probably, I'm going to ask her to summarize what she saw in these videos, yes.
How is that admissible?
How is it admissible is something that she observed. I mean, she can testify as to what she observed.
Okay, so
best evidence would be the
So
video.
that goes back to his objection. Why isn't the best evidence rule implicated at that point, or other evidentiary rules? I guess what authority exists to allow her to testify as to what she observed in the video without the actual video? And is this video admissible in and of itself? So if the video is not admissible, how can she testify as to what she saw on the video? How would that also be, by analogy, admissible?
Obviously we have already submitted video into evidence.
Well, one video. Are you talking about that video or a different video?
No, I'm talking about the surveillance video, and I think the court and even the Commonwealth is well aware that videos are considered to be silent witnesses of whatever events that they record. If I had the videos, I guess I can ask the court to take a recess so I can show her several videos that the Commonwealth just released.
Okay, two questions, or I guess one rule. Yes, she cannot testify to what she saw on the video. Second, are you asking to introduce evidence in the Commonwealth's case in chief?
Obviously, evidence is coming in through the Commonwealth's case in chief.
I'm saying, is the defense asking to introduce defense evidence in the Commonwealth's case in chief?
Not at this particular time, other than the testimony, Your Honor.
Okay. So, again, my ruling is that she cannot testify as to what she observed on the video. I sustain the Commonwealth's objection. My next question.
Okay, so I'll continue to ask the questions, and then the Commonwealth can object and the court can rule.
Yes, sir. And again, to the attorneys, I know that there have been a lot of objections, and there were a lot of objections.
He just says, I'm going to do it anyway.
And sometimes I might be grumpy, but I'm not grumpy at the attorneys, and they are doing their job, so don't hold that against them. That was a cautionary instruction in the beginning. It is their duty to object, to make sure the rules are followed, and we analyze.
He's going to proceed down this line.
Proceed, Mr. Rogers.
Okay. Other than Dr. Parker, were you able to determine the conduct of any other employees that were at Rich Neck Elementary on January 6th?
Okay, and don't answer. So your question was, she able to determine?
Observe the conduct, behavior of other parties, other staff members at Rich Neck Elementary School.
Okay, and in reference to this incident?
Yes, ma'am.
Okay, and your objection is what, Mr. Jenkins?
That's for the video.
Authentication, that she's testifying to that, what she would have seen on a video. She wasn't there. She can't authenticate the video, and she can't describe a video that counsel's not produced. It's the same objection.
Your Honor, if I don't have the videos to produce right now, so she conducted an independent investigation. Obviously, she observed a lot of things by video. If the court believes that she should not be able to testify as to what she observed by video, then I'm prohibited.
So I sustain the objection because it's the same thing we just discussed. And again, if it can't come into the front door, it cannot come into the back door.
There's the back door reference. Second time today.
All right, I'll go to the, let me first talk about you being a custodian of records. Have you testified as a custodian of records for Newport News Public Schools previously?
Yes.
Okay. And so you're the custodian of this document, is that correct?
Correct.
Okay. All right. If you'll turn to page 17 of this document.
Yes, sir.
Okay, it talks, I guess, about halfway down. It says teacher removal of a student from class.
Yes.
Actually, let me start at the very top. It says disruptive students in the classroom. Could you read that first paragraph, please?
Under the disruptive students,
Yes, ma'am.
the code 22.1-276.2 provides statutory guidance related to the initial authority of a teacher to remove a student from class for disruptive behavior. The code 22.1-276.01 defines disruptive behavior as a violation of school board regulations governing student conduct that interprets or obstructs the learning environment. The provisions set out below are supplementary to and are not intended to replace the authority of a teacher or administrator to discipline students according to rules described in this handbook. It is the school board's intent that the process of working with students and parents should be focused on seeking solutions to eliminate disruptive behavior in order to improve student achievement and student citizenship.
Okay. So would you agree that this paragraph, which cites Virginia Code 22.1-276.2, gives a teacher the authority to remove a disruptive student from her classroom?
Objection. That's improper opinion testimony. She's not been qualified as an expert to answer that.
Response.
Your Honor, she is here as an agent of the Newport News public school system. She can advise whether or not she believes that Virginia Code allows a student to be removed by the teacher. It spells it out pretty clearly there, but I just want her to verify.
Just rephrase it. I think you can rephrase it as to not to what her opinion is, right, but as to what's in the manual.
Does this manual, which cites Virginia Code, give a teacher the authority to remove a student from the classroom?
Yes.
Okay. Regarding your investigation, was JT ever removed from the classroom?
Objection, Judge. This is getting into the findings of her investigation now, which is at the province of the jury to decide.
Wow.
And your response?
Your Honor, I'll submit that to you. I'm not asking for a finding. I'm not asking for a conclusion. I'm asking for a fact. I ask her to determine if something actually occurred or did not occur. That's not a finding.
Okay. So again, legal conclusions are a province for the jury. But how is the finding of this school investigation not come? Well, how is that not relevant and admissible?
Judge, the investigation is findings of fact that lead to a legal conclusion. And we have a jury who are the fact finders for this trial. So any findings of fact that are based on her investigation are the province of the jury. And beyond that, Judge, this is beyond the scope of my direct. I did not ask Dr. Parrish opinions or ask her to give any conclusion about any aspect of her actual investigation, because that's the province of the jury.
I'm going to allow it, and over the Commonwealth's objection, the court's rationale is the Commonwealth has introduced the school handbook, the policies, procedures, and the crisis management. And there's been a lot of evidence and questions towards was that followed on that day. So that's a proper subject for cross-examination. And the what the school found and all the school policies can come into evidence. We can have a curative instruction later if parties want that the school findings are not legal findings and legal conclusions for this case, and that is for the fact finders, and that is to the criminal charge of child abuse and neglect and endangerment, not to whether or not the school procedures were followed. So that finding of that investigation is not a legal conclusion. So if that supports the basis, I'm going to allow it in. You may proceed, Mr. Rogers.
Thank you. So Ms. Kovac, if she was having some problems with JT, if he was being disruptive, there was nothing that prevented her from removing him from the classroom. Is that correct?
Correct.
Okay. Are you familiar with Ms. I think I mentioned the name Kovac. I meant Swerner. So I meant Swerner. Could you answer the question in regards to Mrs. Swerner? She could have removed JT from the classroom. Is that correct?
Correct.
Okay. And if Ms. Kovac had contact with JT and thought that he was being disruptive, she could have removed him from the classroom. Is that correct?
Correct.
Okay. If Ms. West had some contact with JT on the playground as a teacher, she could have removed him from the playground. Is that correct?
Correct.
All right. So regarding the multi-hazard crisis and emergency management plan, this is a plan for each individual school. Is that correct?
Correct.
Okay. And are you who's responsible for producing this document, if you know?
That would come under our safety security department.
Okay. Prior to this incident happening, were you familiar with this document?
I know that the schools have them. If you're asking if I'm familiar with this particular one prior to that incident, no.
Okay. And so you have become familiar with this document since this incident has occurred. Is that correct?
Correct. And when you say familiar, again, the custodian of records, it was presented to me. I was not the writer of the document.
Okay. So you said it was presented to you. Other than testifying here today in court, had you read through this document?
Through the entire document? No.
Okay. So your familiarity with this document, was it in preparation for this trial?
For the previous one and this one.
Okay. And would you agree that the policies and procedures in this document apply to everyone that is a employee of a particular school?
Yes.
Okay. So this document would also apply to the teachers in the classroom? Is that correct?
Correct.
It would have applied to Ms. Kovac as a reading specialist? Is that correct?
Correct.
Mr. Rawls in his position? Is that correct?
Yes.
Okay. All right. And so, based on these two documents, was there anything in these two documents that prevented Ms. Swerner, Ms. Kovac, Ms. West, or Mr. Rawls from removing JT from the classroom?
No.
Okay. Is there anything in these two documents that prevented any of those four individuals, Swerner, Kovac, West, or Rawls, from removing his classmates, JT's classmates, from his presence?
No.
Okay. So I'm going to actually go to the page 60 in the multi-hazard crisis and emergency management plan, which the Commonwealth directed you to. Okay. Did you hear what I said so far?
I heard you say you were going to go to page 60.
That's correct. Okay, and even when he directed you specifically to a weapons threat. It says if a student or other person makes a threat with or about a weapon, it has bullet points. Are you testifying that each one of these things should occur?
Say that last part again, I'm sorry.
Are you testifying that each one of these things under this weapons threat should occur?
Objection, judge calls for an opinion.
Your Honor, this is the policies and procedures of the school. She's here as an agent of Newport News Public Schools. She can tell us whether or not it's the responsibility of Newport News Public Schools employees.
That wasn't your question. She can ask you what does the manual say, but your question was whether or not it was applied or followed in the circumstance. So I'm going to sustain the objection.
Okay. So I'm going to ask it in a different way, if I may. Ms. Warner, Ms. Cobat, Ms. West, and Mr. Rawls, was it their responsibility to follow these procedures?
Objection, same objection. He's asking for an opinion of whether they should have followed certain procedures, all of them or few of them.
Response?
I can rephrase it to
no, you've already rephrased
make it more clear, I guess. Are they obligated to follow these procedures? And I let him say this objection.
Okay, do you object to that phrasing?
It's been asked and answered, but I don't object.
Oh, you may proceed with that specific phrasing.
Okay, thank you. So you would agree that if they thought that there was a weapon, that each of those individuals should have evacuated the area. Is that correct?
Correct.
For each of those 4 individuals, if they believe that there was a weapon, they should have...
Objection, Judge. This isn't the question that the court... He proposed to ask her, are they required to follow these policies? That was the question he proposed. That's the non-objectionable question. But he's going down into each of these policies and asking her whether specific people should have followed them at a specific incident or time. And that is an opinion. She has not been qualified as an expert in school security or any such thing. And she should not be offering an opinion about that.
It's not an opinion. She's testifying as to their rights and their responsibilities, Your Honor. So I believe she can testify to that.
State your question.
Was it their responsibilities when presented with...
Whose responsibility?
Ms. Warner.
That's the same question, yes, that I sustained objection to. Next question.
Okay.
Oh, my goodness.
Can I have a moment, Your Honor?
Yes, sir.
I don't envy these defense attorneys. They were dealt a bad hand. If you missed it, if you're just here with us, you missed the early morning session where we had both sides asking for a mistrial. This is pretty tame compared to that. Yes, the objection counter is up to 58. I may have missed a couple. Keep me honest on that. If I missed one, let me know. But, wow. Rusty Jenks, welcome to the gallery. Love that red courthouse. Hope Ain't Fear, gifted a membership. Thank you very much. Sean White, my friend, happy hump day. Meg, thank you as well for the super chats. Is this a real life court hearing? And Iris from Germany. Test message for screen. It's working. OG.
Ms. Ferris, Dr. Ferris, are you familiar with the training that Dr. Parker or anyone else may have had regarding the rights and responsibilities that are contained in this handbook?
No, I am not.
Okay. And would your response be the same to this document? Are you aware of any training that Dr. Parker or any of the staff members may have received regarding?
No, I am not.
Okay. Your Honor, I'm going to relinquish this witness to my colleague.
To your colleague, Mr. T?
Mr. T.
Okay, Mr. T.
Two riders, one horse.
Your Honor, for the record, I'm going to object to bouncing back and forth between attorneys for a single witness and
It's not ideal, but I don't have any authority that says they cannot. Understood.
What?
And I think you got something, Mr. T.
Oh, thank you.
What? It's not ideal, but I'm gonna let them tag team. Get them 2 bites of the apple here.
Good morning again, Miss Farish. Are you Doctor or Miss Farish?
Doctor.
Dr. Farish. You were shown a video of about 16 minutes earlier during your testimony, correct?
Yes.
Okay. At certain points of the video skips forward, correct?
The entire video, I didn't see a skip, but I saw a muting at certain sections.
Okay. So are you aware that the entire video was 28 minutes or 28 or 29 minutes?
Based upon the timeline I saw.
Okay. And you were shown about 16 or 17 minutes, correct?
Yes, as I recall.
And is it your understanding that the video clip that you were shown contains 3 different clips joined together?
The video that we saw here
Yes.
was the whole video except the end. It stopped before the very end. So I'm not aware that it's in snippets. It's the whole video.
Okay.
So now you have to show the whole video to dispute that.
So I'm going to pull up the video, the actual video, the whole video.
Okay.
So now we get to hear the defendant again.
Judge, I'm going to object to this. I don't know what the relevance of this is.
Okay.
They don't care. They're just going to
And I'll give him a moment to respond to relevance.
try to figure out where the HDMI cable goes. Don't break it. You can't just jam it in any hole.
I'm going to ask the counsel not put that up on the screen until we've addressed
That's fine.
Okay, he's objected to relevance. What is the defense response?
It's relevant. The witness has testified that she does not believe that the video has been cut up and, certain parts edited out.
Say that, or did she say she wasn't able to see that?
She says that she believes that the entire video was shown except the end. That's what she just testified to.
Okay. And what are you purporting to introduce and under what legal admissibility rule?
So
in evidence.
So best evidence rule. The Commonwealth has spliced the video, and he's cut out and skipped ahead in the video.
Which we acknowledge.
We acknowledge. So I would like to play more of the video that gives fuller context to the testimony that Dr. Parker was giving in the video.
Rule of completeness is what you're looking
And
for.
when we agreed that the jury would get the whole video for deliberations. So your objection, and what you're going to play is a part of this whole video?
Yes.
Okay, and so what's the objection?
Well, Judge, it is going to be in evidence. I've already fully stipulated that the version we showed is an edited version and that the full video goes into evidence. Now he's wishing to introduce evidence. We don't have that video, the full video in. So the defense is about to introduce evidence that he has, which they can certainly introduce evidence in their case, but this is still the Commonwealth's case.
So the legal principle here, when we start with my
Rule of completeness.
I'm going to allow it in over the Commonwealth's objection. The basis being, if the whole video is going back there to the jury room for deliberation, and it's offered by the Commonwealth, the opposing side gets the right to cross-examine that, and to have it go back there with the ability to cross-examine is not a legally sustainable principle, does not comply with case law. So he gets the opportunity to cross-examine on anything that's going back there in the jury room. So that's the court's basis. You may proceed, Mr. T.
Thank you, Your Honor.
We do have an issue of the video that they have now authenticating it.
And Dr.
Judge, I'm sorry, I just want to advise that the full video many times contains the name of JT.
Understood.
Okay, the whole name, not initials.
Correct, the
Okay,
whole
but
name.
how are we dealing with that, Mr. T?
Your Honor, I don't intend to play any portion that gives the name. I can ask some additional questions if we can. I can try to avoid it.
We're talking about, again, audio and press coverage to the world.
I understand.
So
Yeah.
you're able to not to play portions that do not state and the names of any minors.
Yes.
Okay, you may
But just to be safe, I'll just try to listen to testimony from her directly, and then if I need to, I'll play the portions that I need to.
playing video or not?
It would just depend on her answers.
Okay, you might. Okay. But understand we have that cautionary instruction. We are not releasing the names of any minors. Okay, you may proceed.
Thank you, Your Honor.
My goodness. Oh,
Dr.
man.
Farish.
You playing video or not?
During the narrative that Dr. Parker was giving you in the video of what occurred that day, her actions, did she also mention that in the midst of all of this, she was also attending to 2 other students that were acting out?
Yes.
Okay. And that was not played in that video that you heard earlier, was it?
I want to just refer back to my notes.
And what just happened? We just froze. Give us a second.
Was not just in her office ignoring the rest of the school during the testing, correct?
Objection. It's an opinion about something that she did not observe.
I'll rephrase the question, Your Honor. From Dr. Parker's testimony to you regarding the events of the day, she mentioned that there were 2 other student issues that she dealt with in the school, correct?
Objection. That was the most recent question. It's been asked and answered.
I want to narrow down and go down the path of asking about these 2 other.
Then narrow down.
Repeat your question again.
During the day, during the narrative that Dr. Parker gave you, Dr. Farish, of what was going on regarding her conversations with Mr. Kovac and Ms. Werner, she also mentioned that there were 2 other student issues that she dealt with regarding misbehavior, correct?
Okay, hold on. That's the question. What's the objection, Mr. James?
Asked and
This
answered.
is the second time he's asked that question. Her answer is yes.
Also, just ask and answer.
Yes.
Okay, you can ask it one more time. You can ask it. Go ahead. So
Ask for the 3rd time.
Do you need me to repeat the question, Dr. Farish?
Yes, she responded to other issues.
Okay.
Students' issues.
Okay. And one of them being a student was trying to elope from the school, correct?
Elope?
Correct.
Okay.
Or a student who was an eloper. And
An
this is
eloper.
something that happened.
Right. And that was prior to the shooting, according to your interview of Dr. Parker, correct?
He's trying to escape the testing.
Okay.
Can't avoid the tests. Test what's
Dr.
happening.
Farish, you are an agent of the Newport News Public Schools, correct?
Yes.
All right. And you are aware that the Newport News Public School System is named in civil lawsuits stemming from this event, correct?
Correct.
Many.
Okay. And so your employer has a direct financial interest in these proceedings, correct?
Explain that a little more to me.
Would you, as far as you understand, would your employer benefit financially from having Dr. Parker be the one to blame for the shooting?
Objection, Judge. Hold on, objection. That calls for a legal conclusion. She's not an expert in litigation or how that works. And the question assumes facts that are not in evidence regarding another matter entirely.
And her foundation for having that knowledge or information. So sustain.
Okay. You interviewed Dr. Parker within 2 or 3 days of the shooting, correct?
Correct.
And She gave you permission to interview her and be recorded, correct?
Correct.
Okay. And she cooperated fully with you, correct?
Yes.
You also told her to keep the conversation confidential, correct?
Correct.
Did you ever tell her that she had the right to have an attorney present before speaking to you?
No.
Okay. Did you ever tell her that anything she said could be used against her in a criminal proceeding?
Objection, Your Honor.
This is not a police
Okay, for your
interrogation.
objection?
Judge, we're going to need to address this at sidebar.
Judge is like, what's a sidebar?
I'm asking her what she advised Dr. Parker during this interview.
I'm going to sustain the objection. Next question.
Okay.
Judge says no sidebars. Just keep going. Oh, man. We live here now. This is why we can't have nice things, folks. Right here.
According to your interview with Dr. Parker directed Ms. Kovac to search JT's backpack, correct?
Correct.
Okay. And as far as what Dr. Parker told you, Ms. Kovac did check the backpack and found nothing, correct?
Correct.
Okay. Ms. Kovac also told Dr. Parker that they watched him closely, correct?
If I remember, the phrasing is that they were watching him.
Watching him closely.
Correct.
Okay. So is it your understanding that Dr. Parker had been told that there was no gun in the backpack and also that he had been closely watched during recess?
Objection. Can we clarify that what we're asking her is about the statement, not about the facts of what happened, but about the statement of Dr. Parker?
It's the same. Can you rephrase to clarify what you're referring to?
Okay. Well, I've already asked the questions. I'll move on.
You didn't get the answer. It's okay, Judge. I just wanted the question out there. Oh, my goodness. It's okay, Judge. I've already asked the question. I'll move on.
Dr. Parker also stated that JT's mother would be coming to the school to get him shortly, correct?
Correct.
Okay.
You mind if I may?
Yes.
There's something in the background noise. I'm not sure where it's coming from.
Sorry, that was me, Judge.
Cell phone or
I was playing Candy Crush. Is that okay?
we could try to take care of that. It's very distracting.
Yes, I keep hearing it, and it's distracting.
Okay, well,
Yes.
the sheriff will be on top of that.
Thank you.
And I'm hearing it too, but yeah, we'll work on it. All right, thank you. And again,
Judge, like, I'm not sure if I have authority.
Go to 1 for lunch, but do any of the jurors need a break? Okay, they indicate they're good. Okay, proceed with your cross.
Thank you. Dr. Parker also testified or said to you during the investigation that Mrs. Werner never stated that the student had a weapon, right?
Where's the noise coming from?
May I ask what you're reading?
It's a transcript of the video.
Okay.
Okay.
Do you have any independent recollection of
I
what?
don't remember her saying Ms. Werner said the student didn't have a weapon. I asked her, did Ms. Werner ever say she had concerns about the student and the student being a threat to her or her feeling unsafe?
Okay.
She has her own transcript. She
Do you
just
recall
brought it
when
up
the video was played here in the courtroom?
He's like, okay, cool.
That's what I was trying to remember, if Ms. Werner said that.
Susan.
I remember Ms. Kovac saying she did not see anything in the backpack.
There's her say.
Do you recall the video today where Dr. Parker was speaking to you in an interview and she stated that Ms. Werner never came to her and said that the student had a weapon?
Then, yes.
Okay. And everything that Ms. Werner related to Dr. Parker was about behavior of the student, correct?
Correct.
Okay.
Fun fact, you can follow the money here. Testing, required testing, often tied to funding in public schools. And principals focused.
She also mentioned that they had, prior to this incident, that they had 2 incidents at the school where there was a potential weapon possessed by a student, correct?
You're referring to 2 other times?
Prior to January 6, 2023?
Correct.
Okay. And she also mentioned to you that they've never searched the student without the parents' consent, right?
That they never search students.
Okay.
He's dealt with this judge since the beginning of the case. She's a few months shy of her first year.
And she was also managing state testing that day.
In this type of setting. She has extensive experience, even as a defense attorney, for this.
Based on your investigation, did you conclude that this was foreseeable? The shooting specifically was foreseeable?
No.
Right. In fact, you came to the opposite conclusion, correct?
That is true.
In fact, you said that this is something that none of you could have ever imagined, correct?
I'm going to refer to my summary.
She brought all her own notes. She brought her own transcripts. She's just.
At any point, did you say something to the effect? Oh, okay.
I just asked for a moment to refer to her notes.
Okay.
I do not recall making that specific statement.
Mm-hmm. Okay. But you do agree that this, based on your investigation, that this is not something that was foreseeable?
Correct.
Okay. Did you ever make the comment in the civil trial of this matter that this was something that you could never have imagined?
Objection.
What are those lines?
It's her own statement.
Correct. It's her own out-of-court statement being offered here for the truth of the matter. He can ask her what she believes today, now, but not what she said out of court.
I thought you said during the civil trial. Does that make it in court, or am I missing something here?
It's out of court because it's not within
this court.
This proceeding.
No, I think it is allowed.
She says that she cannot recall. She could not at that time recall making a statement, and I believe she believed I was asking her about the actual report itself that she created.
Okay, well then rephrase, because that's not the question as I understood it.
Okay. Did you ever make a statement during the civil trial that this was not a foreseeable incident?
Okay, no for the answer. So, assuming she says yes, which I don't know what her answer is going to be, are you going to ask her to then give that statement?
I just want to know whether she made the statement.
So you just want an affirmative or a negative response?
Yes.
And your position, Mr. Jenkins?
He's feeding her the statement and just asking her to say, didn't you say at the civil trial? He's going to give her the statement and he expects her to say, yes, I did say that at the civil trial.
I just asked another question. I said, did you ever make a statement to the effect that it was not foreseeable? That was my last question.
Exactly, to the effect that it was not foreseeable. At the civil trial, that is hearsay.
Okay, yeah, understood. And your response to that, Mr. T,
Your
how
Honor,
is it admissible? What exception applies?
I can ask her about her statement. This goes to the
my goodness.
You know what? I will try to question Your Honor. She's already answered that she has determined that it was not foreseeable. So I will try to question. Okay.
Oh my goodness.
No further questions.
Any redirect?
Yes, sir.
Oh, you can't make this up. It's a good thing there are only 2 defense attorneys. Otherwise, we'd have like 6 of them lined up to question this witness.
Dr. Farish, much has been made about your investigation. Do you have, as part of your investigation, did you complete a Rich Neck investigation report?
Yes.
And do you have that report with you right now?
Yes.
May I approach, Your Honor?
You may.
Uh-oh.
Yes, document.
Sure. Believe you have a copy.
Believe you have a copy. It was in Discovery months ago.
Judge, I provided to the defense counsel a copy of the plan. Do I need to wait?
To review what you're presenting to the witness.
Of course.
To make sure that it is the same. Okay?
Very good.
Okay, you may approach.
Thank you. Could you just take a moment to just look at each page of that, compare it with the one you brought with you, and let us know if it's an identical copy?
Quite thorough. I like this witness. She's done a great job. She came prepared.
Yes.
All right, so is that a fair and accurate copy of your complete, full report of your investigation?
Yes.
All right, Judge, I move to admit that as Commonwealth's 3, I think.
Your Honor, I'm going to object. This is the investigation, confidential information, like investigation report.
It's
that
confidential.
contains hearsay from other parties. It's not admissible.
Response.
The court's ruled otherwise already. Counsel has been allowed to elicit her opinion, the results of her investigation. Counsel has cross-examined her about the conclusions that are in that document. We have had a full interrogation about the facts found by her investigation and her conclusions. To not give the jury that document now is misleading. And so for the rule of completeness, the defense has been allowed to go in and talk about cherry-pick little pieces that they want to talk about, and I'm seeking to admit the whole document so the jury can see it for themselves.
Ms. T?
Your Honor, we are on cross-examination allowed to ask about anything we want to ask about. It's launched in the scope of the direct examination. This is a report that contains hearsay statements from other parties, just as the court has ruled that the jury cannot consider the statements of other people that were mentioned in the video. Giving them a full report complete with hearsay is beyond the pale. It's not useful.
Okay. Let me see the document.
Of course, may I approach the... Oh,
You may, yes,
the deputy has it.
Yes,
Yes, of course.
Okay.
Thank you.
Hold, please. Okay. As much fun as we're having, it's 6:30. I've got an appointment at 7 I've got to drive to. We have got to end this at some point. We're going to pick up where we left off tomorrow. Okay, this is beyond the pale. 69 objections is what I count so far. Should have probably waited for one more, but we stopped at 69. So that's where we are now. Hope that you're here. Thanks very much for giving the gift to membership. It's been a long day. It's been a crazy day. This Virginia court is off the chain. It's wild. The judge thinks she doesn't have authority that she does have, and then thinks she does have authority that she I don't know. It's nuts. It's crazy. it's gonna need some more time spent. We're gonna look at it tomorrow, pick up where we left off. Tomorrow we're gonna finish up with day 2 and catch up to day 3. That's our plan. So we can be all the way caught up with the amazing case, which is sort of a train wreck out of Virginia. Thank you all very much. Thanks for your patience. Thanks for our incredible mods who make all this possible and make it run smoothly. You truly are wonderful. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning. Let's start bright and early at, would 9 a.m. work? Is that all right? At the butt crack of 9 a.m.? Butt crack of dawn is what they call it, right? Sorry, that's a little crass. 9 a.m. is what we're going for. I promise tomorrow I'll fix it so that the delay is not terrible like it is right now. Because right now you've got a 30-second delay between when I say it and when you see it. So we'll fix that tomorrow, make it much faster. You guys have a good night. We'll see you in the morning. Bye-bye.